15 and 30 or 2025 to be listed immediately after service.
I remember, but we had issued an entry order also in your favor.
No.
No entry order was granted.
My lords directed.
When do you want? What do you want?
I want that to come up here.
Next week. Give that number.
Can I make a mention online, man?
Well, those who are here, first preference to
Yes,
those people.
I thought it's over.
Yes.
Item 90 of the weekly list, my lord, so covered by your lordship,
Covered by judgment.
my lord.
Squarely covered or only
Squarely covered, my lord.
covered? Put it tomorrow. Covered matter tomorrow.
Item 94 of the weekly list.
1 second. Yes.
In appeal number 1207 of 25, my present is
You want the process to be posted?
For listing.
for listing.
Give it. We'll list you. Why are you need to go? Very agreeable. Yes, next.
After tomorrow, item 29. And from Adjournment.
1 second. All memos give. Give all those memos, posting memos. Okay. Put it next week or week after, depending upon the calendar.
My lords, item 39, the weekly list. I prefer day after tomorrow in supplementary list. My lords. Press matter is
49.
my lord.
You are for appellant.
My lord.
Any urgency?
My lord.
Day after tomorrow, shift it to the daily list. Yes.
Item 25 of the main list, weekly list. Okay, we have issued a copy of the IA.
You want time?
Yes.
All week after next. You tell other side also.
Other side I am.
All. Item question. Next.
Item 17, my lord. I am for the respondent, my lord. And I am for the appellant.
What you want?
I pray for a short adjournment.
Short accommodation. Which year? Which year matter? 24. The week after next set the request now. Finally.
Item 6 of the weekly list.
The
rate of bill filed by the Union of India. I have already informed the officer for next day because I have to receive something.
Week after next I will have. Week after next set the request of Senior Penal Counsel. CGC.
Item 236 of the weekly list. Earlier, 1 week before it was listed. I made a mention to take up the matter, state appeal. Today, 236. Also directed to supplementary list. But today, can again come to 36.
Which year matter?
25 notice has not been issued. And the
contract that shift it to the
236 one.
36. Because in the meantime, the counting is over and he has been answered. She has been answered.
47. You are for?
I am for the appellant.
Learned counsel appearing for the appellant submits that matter has become infructuous in view of later development in connection with electoral process. Next, ordered accordingly, and petition is disposed of. Petition or appeal?
Petitioner, sir.
Appeal is disposed of.
47 of the weekly list.
Weekly list. Okay.
My lord, item 94. I pray the lordship take up this matter in supplementary list on any date.
Which year?
2025.
Any urgency?
My lord, the appellant is in ICU and he is not getting you.
But how the judgment copy becomes the medicine?
No, my lord, please.
Shifting to daily list. Yes.
Number 20, weekly list. Item number 20. On behalf of Senior Counsel, Mr. Tripathi, my lord, I only pray let it be taken up next week. My lord, he is out of station.
Next week we have the week after next week can I have?
And one more prayer is, my lord. One affidavit has been filed by OP number 2 and 3. That is not on record.
In that list itself.
Yes. I pray, my lord, that affidavit may kindly be brought on the record.
Affidavit to be placed along with the papers.
There is entry model. Entry model.
Entry model is there.
Not sir.
Wherever the entry model is there, continue till next date of hearing.
Grateful.
Can I make a mention, my lord? Now can I make a mention, Lord?
Yes, sir.
Lord, the petitioner it is a case of 2019. The petitioner is now aged about 65 years and is suffering from cancer.
You want posting of that matter?
No, I'm praying for to list the matter here.
Yeah, give it.
That is what that is.
Give, we will list it tomorrow.
Public content. Yes, but tomorrow may be listed.
Day after we will have it.
My lord.
It is already ready. Day after we will have it.
My lord. Oblige.
May I have my lords kindly
Speak to the number you have to send. Yes.
I'm giving memo, my lord.
Give memo.
May I, my lords,
Yes, brother.
may I, my lords, kindly leave to
brother.
mention may I, my lords, kindly leave to mention a matter, my lords. My lords, in this matter, my writ petition was allowed by an order dated 9th May 2025. Now, my lord, at the instance of the private respondent, my lord, an appeal was preferred and a stay was granted on 27th May 2025. My lord, I was
What?
praying yes, please, my lord, inclusion in your lordship's list, my lord, because I'm suffering an order of stay when the state respondent has not preferred an appeal. Yes, my lord. My colleague is there.
We are agreeable to you. When we are agreeable to you, why you argue? When we do not agree, you have to argue.
I'm sorry, my lords.
Tell
Sorry.
which date you want.
Any date convenient to my lords, my lord.
Post it any date. Yes.
No, any date convenient to your lordships, my lord. Kindly give a date.
2 weeks it will come. Okay.
Grateful, my lords.
Right, supplemental list item 1.
Right, please.
One and two complied, your lordship.
Now kindly peruse the last order dated 25 to 2026.
26 to.
23.
Contempt matter.
Yes, please.
What was the order and where is the compliance?
Your lordship, we've received the instructions that it has been sanctioned on 17/3/2026, 1 and 2, an amount of 8,49,410 towards payment of decretal dues in favor of Prithi Basi Sahu. Yes, and another, your lordship, of 27,94,831 in favor of Ishwar Chandra Sahu, your lordship.
Yes, there is compliance. No.
No.
Yes, your lordship.
I have been.
What you have instruction? They are giving, na?
Day before yesterday, I have taken instruction.
All right. Right. It's a matter between court and our, they have nothing to do. You are only a postman to bring to our notice. That's all. When this money will reach them?
Your lordship, the DD has been made.
DD has to go.
They have said a demand letter. They have also issued, your lordship, in the next.
You have credited it to Treasury.
That has to take instruction. This has come to me that they have already sanctioned the amount towards.
It's already sanctioned.
Sanctioned.
Concern, but I don't know this.
There's already demand number, everything is there.
To keep will also be another date, but I will take the instruction.
Yeah. Not the important bench of this court, while order dated 19/11/2024, in complainants WPC number 28451 of 2024, had given the benefit in terms of para 6 thereof, which reads as a what it after service of notice, the concerns having entered appearance through the learned AGA, after service notice, fresh matter
Yes, your lordship.
in advance.
No, your lordship, it was listed on 25/2/2026, your lordship.
Yeah. The contemners having entered appearance through their through the learned AGA, Timothy so have filed a set of documents. First up, the letter dated 73/2020, number 8341/WR dated 70/2026, addressed to the office of the learned of the Advocate General, reads as under. Right? Next paragraph. The fax/email number 8309/WR dated 73/2026 reads as under. This is a question. Yes. Yes. A perusal of these two, the above two letters shows that the contemner is being reimbursed the amount due in terms of order of the coordinate page. First one. Learned AGA submits that the credit of the said amount would happen before long. And there is no reason to doubt this version. And therefore, we do not grant any adjournment at the request of contemner, contempt essentially being a matter between the court and the contempt complainant, the request of complainant. Okay. First, in the above circumstances, the proceedings are dropped with a warning to the contemners to ensure payment of the amounts specified, amounts of money specified in the above subject letters within an outer limit of 1 month, failing which it is open to the complainant to revive the complaint for aggravated offense of contempt. In that event, heavy costs payable by the contemner personally may happen, in addition to possible confinement. Next.
Item 2, content 5814 of 2000.
1 and 2.
1 and
Same order. Next.
Item 3, WBC 5896 of 2026.
Yes,
May I please?
Huh?
May I? When petitioner number 1, husband, and the petitioner number 2 to 3, father has died, and thereafter he has availed a loan of home equity loan. They, as at the time of availing loan, they have made a condition that you have to take a LIC policy of 58,885. As per the statement.
Now we have made OTS offers.
No, that is not a fact. Fact is that we
Now your prayer, we are speaking what we should do with the fact. Kindly come to the prayer column.
My lord, kindly see the statement. Two different statements they are providing.
No, they are asking you to, when the judges ask you,
My lord.
request you to read the prayer.
My lord.
Generally, when
My
we
lord,
were at the bar, we used to read.
My lord.
Unless you have justification for not reading it, then read the prayer.
My lord.
Yeah.
My prayer is Annex 7, claim of life insurance of Jagabandhu Sahu for equity home loan bearing as insurance amount rupees 58,855.54 for 10 years they have deducted. At
Where
the
are
time
you
of
reading?
sanction.
Read the prayer of the
My-
petition.
My lord.
Settlement of loan account number so and so would
My
not
lord,
be
my
considered. Consider again, there is wrong under OTS scheme as full and final consideration. Insurance was there.
Yes. And not
You take notice,
My lord.
issue an urgent notice. Post immediately after your learned panel counsel appearing for the learned panel counsel on the volunteers to appear for ROPs
1, 2, 3.
1 to 3.
My lord.
Why Reserve Bank? You make finance ministry also a party.
Can I read it?
Notice to R4 is dispensary. Okay. When we should call this matter?
Let us copy.
I have the instructions. So he was touching the ceiling of the age limit as insurance. So insurance rejected, so that premium was credited back to his account in 22 much prior to the death of the father. So there was no insurance. And there were
To file a short statement.
2 loans taken.
Correct.
The first loan he is mentioned.
Draft a small statement counter, put it so that we'll pass appropriate hours. Call after 2
My
weeks.
lord, copy.
Yeah, fine. Next.
Item 4, WBC 8410 of 2026.
Lordship, may I accept my fresh wakalatnama?
He goes appear for
Petitioners.
petitioner. In the place of,
No, along with my brother.
along with a battery of brothers. Always.
My lord, here on 23/1/2006, I availed a house building loan. Housing
23.
loan. 1/2006.
Housing loan.
Yes, amounting to 27 lakhs. After depositing some amount, it became NPA in the year 2025.
Some amount means how much money you have paid back?
My lord, out of 27 lakhs, now their dues claim is 16 lakhs.
We are asking you, how much you have paid?
My lord, I have paid 13 lakhs 50,000.
13.50.
No,
50. 50.
Yes. Now they have published a notice under Annexure 14
Yeah, e-auction.
demanding 16 lakhs from me.
Yes.
My lord, in fact, I'm ready to comply with them, but some time if is given, I'll fully comply their dues. My lord, the auction date is on 26th of March. But I'm ready to deposit 2 lakhs at the moment upfront within 10 days.
Out of 16 lakh, 2 lakh you will be.
I'll immediately deposit within 10 days. And if they reconcile my account within 3 months from the date of reconciling my account, within 3 months, I'll clear up the entitlement.
You deposit 50% of the amount, we'll consider your pay.
50% at the moment is difficult on my part.
Then let it be auctioned.
My lord, you're not.
As if there is, as is what is. On that basis, whatever there is, that's how it reads. So,
my lord, I'm aware. My lord, I want little, some respite in the first lap. In the meantime, 3 months I'll deposit. First lap, I'll want a little respite from your lordship.
No, therefore we said 50%.
Well, it's something less.
You 50% will be how much? It will be 8 lakhs.
8 lakhs. 8 lakhs at the moment I cannot. If your lordship may grant me 3 lakhs at least, I'll pay.
5 lakhs. 5 lakhs.
My lord, 5 lakhs. Lordship may give me 2 weeks time, I'll deposit 5 lakhs.
This petition seeks redressal against the coercive action of wide recovery of housing loan of January 2006. First off, an e-auction sale notice dated 24 to 2026 is available at Annexure 14, and it tells us that the auction is scheduled to be held on 26/3/2026 for recovering a sum of rupees 16 lakh, which is stated to be outstanding. First option.
That is 16 lakhs, 5,000.
16 lakh, 5,695.
95.97.
Instead of 695, make it 696. As on 23 February 2026. Correct?
Yes.
Plus interest. Plus interest you did not disclose. You have to be fair to the court. When one litigant comes to the court, litigant has to stand bare before.
My lord, it is my mistake. And interest and other expenses there.
What is the interest?
My lord, that they will calculate and tell us. That's why.
Then you deposit 30% of the amount in demand.
On their face of it, it is 16 lakhs.
16 lakh is not, it does not include the interest.
Yes. My lord, I will deposit 5 lakhs.
No. What is this? First one. Learned counsel for the petitioner submits that his client is a bona fide customer of the borrower, in as much as he has already remitted a sum of rupees 13.50 lakh towards the loan amount, and that he is ready and willing to pay some more amount if a reasonable period is prescribed for doing that. First up. He lastly submits that if the house property is sold, someone is trying to be put to a manifest injustice and a great hardship. First one. Next one. Having heard learned counsel for the petitioner and having perused the petition papers as well as the papers in the application in IA number,
well, that is IA number
5096 of 2026, followed by the affidavit, we are of the considered view that some reprieve should be granted so that justice would be done to both the sides. First of course, this cannot be done unconditionally. First off, next paragraph. In the above circumstances, the subject application having been favored, the bank is restrained from processing the matter any further pursuant to the impugned e-auction notice, subject to petitioner depositing 30% of the outstanding amount as on this stage within in two weekly installments, within two equalized weekly installments, failing which not only the interim order stands rescinded, the petition itself may be dismissed from that path.
I'll take notice to the bank.
I will file in my duty minutes if I will not bring that back to the notice.
The office may be directed to indicate my name hence.
These people print the name of. Yes.
But I will fill in my duty minutes if I will not bring the actual part to the notice of a minor spend. That matter, this matter I am tracing today, that was in a different form, of course, before the Honorable Court.
Serial number 5.
Serial number 5. So that same matter by same parties, a little different prayer, that was before the Honorable Court. That is in WPC number 5336 of 2026. 5336 of 2026. Their minors.
Is it pending or?
No, the minors, some argument, some length of argument, the petitioner wanted to withdraw the writ petition.
Withdrawn on?
Withdrawn on 18/2/2026. Thereafter, what happened, minors? The bank, it's a case, minors, two of the MSME units availed a loan from Canara Bank. They went on paying amount till 2024, more than 7 crores they have taken loan, 7 crores, 63 lakhs amount, so they have already paid. But of course, it is relating to interest and all these things. In the meanwhile, 2024 it was declared NPA, and thereafter the amount.
What was the loan taken?
Loan 7 crores.
In which year?
2014.
Business amount. 2013.
2014.
The business loan, it must be obvious. Business loan.
It's a industry, established MSME unit.
And now what happened? How much you have paid back?
We have paid back the total amount I calculated. For minors perusal, it is 7 crores 63 lakhs 55,355 by 24 and 25. Before it was held in payments, I become defaulter.
This was repaid in which year? Last
2020, up to 2024-25.
And now what is the amount due?
Amount due as per then by the time I filed writ petition, this auction notice was not there. Now auction notice has come in Annexure 1, page 23. They have shown the amount 13 crores 74,416 as on 28/2/2026.
About 13.75.
In the meanwhile, some amount also will accrue because if the interest thereafter also can become.
Yes.
My humble contention was there, my lord.
This auction notice is dated?
Dated, my lords, 10/3/9/3/2026. 9/3/2026.
Auction is scheduled to be held on
26th. 26 March. Well, this is 26.
Are you ready to pay 30% of the amount?
That minors have already stated, minors, I'm conscious of the position. I learned it from the council appearing there. Minors are already in that option, minors. So that I'm conscious of the position, minors. Only one line, minors, I will say. Here in this case, suffice proceeding is going on. And the bankruptcy proceeding, insolvency proceeding also went up. Insolvency proceeding, bank appeared. Minors knows that the insolvency proceeding once started and the resolution person appointed and it is under interim resolution. All this debt cannot be recovered. That is the statutory provision, and that minors knows that. On
no, I do not know. Give that judgment.
My sir.
Justice Nariman's judgment.
Justice. Remember best decision.
2016, 17.
No, this is very recently, my lords. That is 2023. Well, sir, I'm not entering detail. Kindly have a glass of the last page. Because of that, the Honorable Court concluded this in a different way. Well, sir, clause
Purpose of interim moratorium.
Yes, moratorium under section 96 is to protect the debtor from further legal proceedings. My humble contention was that this proceeding is there, bank has already appeared there, this proceeding is continuing. Under such circumstances, suffice proceedings should not be taken up. Because ultimately, what will happen? Suppose this bankruptcy proceeding, that insolvency proceeding would accept. Because already proposal, insolvent person appointed has given the proposal. The proposal is accepted, but then also
Against this order, how these contentions you can make under section 17? Why we should interfere?
No. My humble contention here is not this. Section 17 minus refer to Surface Act.
Correct.
But I'm on.
Action is under Surface Act now.
Action is under Surface Act, but question is all such proceedings.
Yeah? Correct.
But all such proceedings should be stayed. Well, so it remains stayed in view of the operation of that provision of the law.
No, that way you can put forth before the section 17 DRT. Go before the DRT.
I have filed a petition before the DRT. 5 remainments with due humility, by I may be excused. They are
not taken up.
No, but the situation is something different, my lords.
No, you want it to be taken up.
It to be taken up immediately, my lords.
We will tell them to take it immediately.
My lord says so. I will oblige.
Yes, is it essay number?
Yes.
Essay number.
Essay number 114/2025. But nothing in spite of the order of my lords also not been taken up. The presiding officers are equal before to appear before the honorable court after
why did you withdraw the petition, earlier petition?
Well, these earlier petition, they probably could place the detailed matter in that petition is pending before the DRT. We can go before the DRT. We have filed a petition before the DRT stating all these things. My friend failed to appraise it.
Whatever your friend has failed, that failure is attributed to your client, who is your client also.
Oh, my, that is exactly my I bowed out, accepting equity matters. I can have a position. It's of a law is concerned.
Will not interfere, but will tell the DRT if you agree.
No, I have already filed a petition. I have already filed a petition that is there in spite of repeated request is not being taken up in this step. It is a perennial problem there.
Petition prayer reads as under. First off, learned counsel appearing for the petitioner borrower, which is MSME, clearly submits that earlier WPC number 5336 of 2026 having been withdrawn unconditionally on 18/2/2026, is claimed to be satisfied, regardless of the text of the prayers in the present petition, if a direction is issued to the DRT to hear and dispose of essay number 116 of 2025,
and interim petition filed therein,
or at least the application for interim prayer filed in the pending essay on a war footing, keeping open all contentions of the parties in view of the urgency, namely the auction scheduled to be held on 26/3/2026. First off, this prayer being innocuous and reasonable, cannot be rejected by a writ court which exercises equity jurisdiction. More particularly when the interim application for reprieve is kept pending in the subject essay. First, next paragraph. In view of the above, the petition is disposed of, requesting the presiding officer of the DRT to take up the subject IA tomorrow for consideration.
May I urgent copies of that.
There's nothing like that.
I think download copy will be there, my lords.
Ordered accordingly and writ petition is disposed of. Next.
Item 6, WBC 89. Item 6, WBC 892 for 2026.
Members, Mr. 1 minute, my lords.
Yes.
I know that the teachers will play by the registry complicated.
Why, we will post that copy right now. You will get it.
What manner you will get it? All right, man. So we'll do that.
May I please be notes?
Yes. Or can we say within 2 days instead of tomorrow? Within 2 days, he will take up that.
Okay, my lords, because there, it's not 26, my lords. By 25th, they can take up.
Next.
May I please
Item
be notes?
6,
The petitioner, my lord, is an MSME. The petitioner is an MSME and he is a borrower, my lord, for opening of an industrial unit at Balasore on a IDCO land. Here, what has happened, my lord, if the lordship would to kindly see that the auction, my lord, in this particular case, the first auction, if the lordship would kindly turn to page 104, annexure 15 series, on 25th of November 2025, they say, my lord, that the reserve price.
What is the amount due as on this?
According to them, my lord, if the lordship would kindly turn to page 110, they say it is 1 crore. Demanded amount is 1 crore 2,27,903.70. That is page 110.
1.02.
It's one for
CR.
Plus. One. What has happened in this case, my lord? I have 2 full submissions codes. Within a month's time, because there are 3 auction notices which have been given. The first auction, they say, my lord, the reserve price is, my lords, 83,037. 83,37,000. That is on 25th of November 2025.
Yeah.
They again publish a second notice, my lords, where, my lord,
For lesser amount.
the second notice, that is on 8/1/2026. Your lordship may kindly mark the date. 8/1, they say, my lord, for 75,000, 1,79,000. Then, my lord, in the month of February, that is 27th of February 2020. Third auction, they make it as 42,24,000.
Yeah.
My humble contention, my lord, is this reduction within a month. Your lordship may, for the moment, ignore the November notice. Between January to February, my lord, there has been a reduction of 41% minimum.
From 70 plus to
40 plus. More than from 40. And your lordships, my lord, in the recent judgment, the Honorable Supreme Court has said, well, the valuation is, even though it is under the RBID Act, it says that it is a subject matter of judicial review. So in a concluded sale, they have again remitted back the matter, please ascertain, because the job of the bank is not only to sell the property and get whatever money they get. The fair market price has to be achieved. So if your lordship would kindly see the judgment of the Honorable Supreme Court, the last paragraph, I need not bother your lordship.
No, we are aware of that. Just we will not spend time on it.
But true, man.
Yeah.
So my first humble contention, my lord, is within a month's time, there cannot be a reduction. And the depreciation, even though your lordship would consider, to be more than 50%, number one. Number two, my lord, being an MSME, my lord,
but depreciation is as between second and third, it is 40 plus.
41%.
41.
Between the first and the present one is more than 50%.
No, for first you did not raise any.
My lords, but my lord, between the second and the third, it is around 41.41%, roughly 42%. So within a month, my lord, there is assets.
Have you produced to say that it is drastically low? Having the comparative value of the previous notification.
My lords,
have you produced any sub-registrar guideline values?
Unfortunately, my lord, so far as Rule 9 is concerned of the securitization rules, my lord, it says, my lord, market price.
No, for a part. This is even under land acquisition.
My difficulty, I advised my client, I tried it. Unfortunately, physical possession has been taken out by the bank. So a registered valuer was not allowed to enter the premises, my lord, for assessment, because now for the first time, they also put the machineries into auction also.
Well, but auction is
scheduled for the 30th of this month.
30th of this month.
Mine.
you take emergent notice.
My learned friend is on caveat. My
You are
learned
appearing.
friend, but I've already served a copy on him.
What is
And
essay is pending, my lord.
essay is pending.
Lord,
We direct the DRT.
what has
Say
happened?
immediately.
Essay, my lord, essay was against 13-2 notice.
You make application in this also.
No, what has happened, Lord? Why I have come, my lords? That this essay, in that essay, the bank is taking time to, in a 13-2.
We will tell them not to take them.
No, they have taken time because now, my lord, if your lordship not protect me, the entire property would be sold at
No, but
30.
tell the
And all these
DRT, took up your matter along with your application, which you will move now.
May I just humbly pray, my lord, subject to your lordship's kind consideration. Your lordship may
Are you ready to pay 50% of the amount? Otherwise, unconditionally.
No,
See, you have remedy. Please keep quiet. Keep quiet. Keep quiet. You have remedy at the hands of the DRT. DRT is a statutory body.
True, my lords.
And the presiding officer will have accumulated wisdom because every day he treats such matter. That is the object.
But in the previous matter, I need not say more, my lords, because I am intimately connected with the DRT in another capacity, my lord. I'll not bother your lordship with that, my lords. We have, unfortunately, very, very sad experience with the present firm, where properties were sold off, where orders of this honorable court was passed to take up this matter expeditiously. The DRT, the DRT says that even that the DRT says that let the bank file an objection. When there was a specific direction that please request of this honorable court was to please take up matters expeditiously.
But unless your client shows bona fide, the money attracts the rate court.
True. Your lordships are very correct.
Yeah.
So may I just pray,
attractors, making some attractive offer.
May I just humbly pray, my lords?
Yes.
Your lordship may give me time till tomorrow, my lords, to take instructions. Your lordship will call this matter and 50 or whatever, my lord, is his offer, my lord, I'll come back to your lordship. But without instructions, I can't make that offer.
Well, we call it tomorrow.
And the day after,
The request of learned senior advocate.
Day after tomorrow.
Day after. But there will be left time, very
there'll
little
be no time for me to
out.
deposit.
No, call tomorrow. Yeah. Next.
No, can it be tomorrow? Much
tomorrow.
obliged.
Item 7, Read Appeal 1370 of 2025.
And please, your lordship. As for my lord's order related my lord's chamber. I'm just saying that please will be it. Yes, otherwise, let's say we'll pass some stringers, not deciding matter, nothing. Yes.
Pursuant to my lord's order dated by 10 March 2026, my lord. We have
Read the number.
Let's go and request.
Yes, 2026.
My lord.
What is this matter, brother? Cost.
Only my lord.
8,320. Have you paid it?
Yes, my lord. We have deposited the cost before.
You have deposited already?
And my lord, due to want of time, my lord, the deposits notice has not issued.
You issue note, no, you give requisites.
We have already requisite filed.
Requisites you have filed.
My lord, on these ones. 70
Why the order, our order dated 10/3/2026, we had said as under. Next paragraph. Learned EAC appearing for the appellant submits that a sum of ₹8,320 has been remitted to the registry as a precondition in terms of the above order. First off, he further submits that requisites have been belatedly filed and the direction be issued to the registry to process the same immediately. We agree. Registry to process. Next.
Item 8, Read Appeal 1934 of 2025.
Please, your lords. Madam, report of appeal, my lord. It appeal, my lord, is a delay.
147 days.
My lord. And my lord,
What is the matter on merits? In condoning delay, the meritoriousness of the main matter is also one of the factors. Tell us on the merits.
my lord, the respondent, my lord, was appointed by the Christian Managing Board, my lord, I'm placing, my lord, the dates, my lord, on 1998, my lord.
Where is the prior approval of the government? Which rules said? There were no rules only.
That is there, my lord.
That is the reasoning of the 10.3. That appears to be sensible.
Lordship, that about, my lord, he was not eligible at the time of, my lord, his engagement.
Where is the eligibility condition? How you will say whether one is eligible or not?
Basic requirement so far as teacher is concerned.
Where is that? Show that. You have to come with that. Where is that basic requirement? Where is it prescribed? Show that. Well, no cowherd can be appointed, no shepherd can be appointed as a teacher is true. But if some process of ascertaining the credentials has been undertaken, and there being no rules, no guideline, no memo, no circulars, therefore, learned single judge said there is no 10.3.
Let's use 10.3.
Read 10.3. Placing reliance on the decision of apex court in or that Ranjit Singh has been followed.
Yes.
In view of this, that's the time, since by the time petitioner was appointed, no such rule was there requiring prior approval of the government. It is the view of this court that provisions contained under para 5.3 read with para 37 cannot be made applicable to the claim of the petitioner as it take away the right already acquired in her favor. It is also the view of this court that since the petitioner was appointed as against an approved vacant sanctioned post and the said employee after taking retirement is enjoying the benefit of pension, the petitioner is eligible and entitled to get the benefit as paid for. Therefore, this court is inclined to quash the impugned rejection so made by the government opposite party number 1 on 7/12/2020 under Annexure 6 while quashing the said order.
Now she has retired also.
Yes.
After post-retirement, you want to call her back credentials with the retrospective effect. How? You should leave the retired people to live in peace because they are in the evening of their lives. Long before you should have taken. How many years of service?
98 to 2023, 25 years.
25 years?
Yes. Appointment on 7/8/98 and retired on attaining the age of superannuation on 31st March 2023.
2023?
My lord. Did that during the pendency of the petition. Retired.
Appointed as teacher?
Teacher, assistant teacher.
Assistant teacher?
Yeah.
What was the qualification?
Qualification, my lord, the city, my lord.
City?
Yes.
No, metric city?
Metric city.
Matriculation is
City.
certificate.
City is the training qualification.
It was in which class? For which class?
Primary school, my lord.
Primary.
Primary school. Initially, my lord, in the
Dismissed.
Bullet.
Agreeing with the reasoning of the learned single judge. Gained entry to service on 7/8/98. First off, demitted office on 31/3/2023 as assistant teacher. First off, possesses matric and
City.
First off, at that time, no rules were there. First off, long and what a service. Public court decision in R. Ranjit Singh.
I have also made copy, my lord.
Well, right. No, for short notes, but
Only, my lord.
the order of the learned single
Yes.
is to be implemented within an outer limit of 8 weeks.
She's suffering from cancer. That is why I made a mention last occasion. It was in the weekly list.
Implemented and a report of complaints to be submitted to the Registrar General of this court within 8 weeks. Failing which, heavy costs may be levied in thousands of rupees payable by the hearing officials personally. Now no costs. Next.
Item 9, Read Appeal 1946 of 2025.
Read, please, my lords.
Yes.
This, my lord, is that appeal of RSCP, my lord, will recollect. I had shown RSCP was wrongly given to the respondent. That RSCP was to be determined and fixed by the municipal corporation. The respondent is a
But government directed,
that order.
you showed that other day that there is a government direction to make the payment.
Pursuant to order of this honorable court.
My lords, let me clarify the situation. My lords, I had handed over two resolutions.
Yes.
That my lord will kindly.
Were they part of the record there? No, we will not take it. We are not a tea shop. Unless they are moved along with an application. Almost on par.
My lord had this with them, my lords. On last occasion, my lords had passed the resolutions in relation to the provision of the Constitution 243W. That the municipality as an independent.
Did you take up those contentions before the learned single judge?
My lord,
Did you place this material before the
I could not have. I could not have because no notice was issued to us. That was my contention. My lord had asked me the question. I had showed the ground. Then my lord was in fact pleased to grant me some time to file an application for condonation of delay. Only on that ground, my lords. After my lords was satisfied that there is a case, I was allowed to, my lords, file that delay application. I have filed it. In the last occasion, unfortunately, I could not be present. My junior was here. He could not answer those questions. So after my lords listening to me from 3 takes, my lords was satisfied. Only then my lords were pleased to give me that opportunity to file that application for condonation of delay. I was only to file the application and come back to my lords. My lords, in fact, directed me to find out a judgment of the Karnataka High Court. That I have done.
What it said?
That writ appeal will not be dismissed only on grounds of delay just because the delay condonation application is not filed. And after having told me of the judgment, my lord had permitted me to file the application.
This is Venkatachala.
My lord. My lord.
Now application is filed.
It's filed.
For condonation of delay.
My lord. The review application, my lords, was filed with delay. The writ appeal has not been filed with any delay. The review was dismissed.
You on the ground of not condoning delay.
My lord.
Not on merits.
Not on merits.
I may be permitted, man. The petitioner was allowed the respondent was allowed the RSP benefits while he was in Bhubaneswar municipality, man. He was
that's on merits. No review is filed. No. He says there is error apparent on the face of the record. But review was filed belatedly with no application seeking condonation.
No, my lord. Which application for seeking condonation?
Here, my lord. Because I had challenged both orders.
He has filed it here.
Yes.
No. In review, he should have filed it.
I filed it in review. I filed it. Because I have challenged both orders, the order for review as well as the original order. The original order, I had not filed a delay condonation application here. That my lord permitted to do.
But when the direction is given by the government to pay the benefit, and how can you disobey? You cannot be more loyal than the king.
That is my lords, because the government specifically passed a resolution saying that for a municipal employee, the entitlement to this RSP benefit is to be calculated by the municipality itself. Now, just because the petitioner came and filed a writ petition in this honorable court to dispose of a representation to the government, which he should not have made, my lord, in the single bench, without having given an opportunity in that case also to file a reply, relegated to the government to pass a decision. So it was never the government's jurisdiction at all. That is my contention. And in fact, Municipal Board of Hon'Ble, my lords, 1972 AR also, the Municipal Board challenged a decision of the government in the Allahabad High Court. The Allahabad High Court dismissed it. The Honorable Supreme Court has upheld it. So, my lords, my only contention is once the burden of giving that benefit is conferred to the municipality, it's the municipality's decision because it has to pay from his own pocket.
So, what happened to whom you have already extended this benefit?
The Kotak municipality also extended my lord.
No, we haven't. It's the Bhubaneswar Municipal Corporation which has done it, and that is done wrongly. That we have specifically written to the government that those benefits that you have granted or approved on behalf of the BMC, they should not have been done.
That is by BMC.
By BMC. And in fact, the post to which he is claiming RSP, the grade pay that he is claiming does not even exist. So those employees are taking that benefit illegally. We have written to the government because the burden is to be borne by us. At least my lords, I should be heard.
I may be permitted, man. That is not the case.
How many days of delay now?
484.
Now, my lords, with the review pending, then was 484. The review was 370 days. Now, my lords, it was pending there for some days before it could be decided. My lords, total now is 484 days. Original order.
484
days.
84.
My lord.
Into 20, how much it will be?
9680.
You take that money.
No, my lord. I may be permitted. I have given one death charge, my lord. Also, kindly pay me. The case of the respondent.
Condonation of delay also have objection.
484 days delay, they have not given any sufficient grounds for condonation of delay. That is the case is not maintainable at all, my lord.
That we will examine. First, let that money come. Receive that money first. Pocket use.
Before
Two
occupying
applications are filed for condonation of delay.
No, my lord, only one.
One application.
Only of the original order, my lords, there is delay.
So long. I'll peruse the list of days I have submitted, my lord. So
What to do? That's on merits.
the benefit has already been allowed in favor of the
Delay control. Application also delay control. Yes.
There's an application for stay, my lords, the contempt is proceeding. My lords have been pleased to allow me to have that application deferred, but it's there. I mean, it's been now posted to
Since
10th.
matter requires deeper examination, comma, all this in the third week of April 2026. Until then, the respondents shall not precipitate the contempt proceedings. Pending before whom?
Learned single judgment.
Pending on the file of learned single judge of this court. Okay.
my list of dates may be taken to record.
Eh?
I have submitted today the list of dates, my
Keep it in the record.
May I file those resolutions as an additional affidavit? So
Then you have to file application
ma'am,
with the leave of the court.
ma'am,
You have to place them on record.
ma'am.
Yes, next.
Item 10, DWPC 7775 of 2026.
Application mentioned. Yes, signs. Yes, 10.
On behalf of Mr. Swai, Your Lordship.
Ah,
On behalf of Mr. Swai, Your Lordship, may kindly permit me.
yes, sir.
My lords, there has been a defect pointed out by the
Registry.
my lords
Ah,
about legibility of 3 pages, Your Lordship. Those are documents of the encumbrance certificate.
all right, keep them all right. Now, the office objection being insignificant, he is overruled. Okay, argue on merits.
My lords, innocuous prayer before my lords. I am the auction purchaser. I have deposited the entire bid amount of 1 crore 35
What the
lakh.
prayer?
Prayer is twofold before my lords.
Dispose of your essay number
Essay of the-
161 of 2024. We'll
Essay
tell them
of the
to
borrower.
dispose of.
Essay of the borrower, Your Lordship. I am the auction purchaser.
Correct. We'll tell them, are you a party there?
I am a party there, Your
And
Lordship.
then we'll direct them to dispose of the essay.
As my lord pleases.
No, that's your prayer.
The
The
other
prayer,
part is also there. He disposes the
prayer of the auction buyer of the auction buyer of the security property reads as that. Next paragraph. Learned counsel for the petitioner submits that if a direction in essay number 161 of 2024 is direction is issued to the DRT to hear and dispose of pending essay number 161 of 2024 within a reasonable time, keeping open all contentions of the party, justice would be met to all the stakeholders. First, we agree. Next paragraph. In the above circumstances, petition is disposed of accordingly. That requesting the DRT to accomplish the task within an outer limit of 3 months.
my lords.
First of all contentions kept open. Next.
May I pray for an urgent copy, Your Lordship? May I pray for an urgent?
Get web copy to be acted upon. We are making it printing it in every order.
Grateful, Your Lord.
Yes.
Item 11, WPC 329 of 2012.
Item 11, my lord. Your
What
lordship,
sentence you put?
last occasion,
He distance to things were possible. Innocuous.
last occasion, your lordship directed me to take instruction regarding adjustment of these employees.
What was that? We don't remember. Can you give a little more detailed description of the case?
My lord, there were vacancies. My lord, 40 vacancies were filled up. 40 vacancies were advertisement because that was the vacancy position. There are 65 additional vacancies beyond vacancy position were appointed. Those who were appointed within the vacancy position, they were regularized. But these 65 persons, they are moving around.
They are?
Moving around. They were not regularized. Some were died, some were retired, some were died, and this in this way. So your lordship directed me to my friend, my lord, to obtain instruction whether these people can be accommodated or not.
Direction for regularization.
Yes.
Is it prayer is for appointment?
Like regularization.
Regularization.
No, my lord, I may just put it. First, there is some fact is not correct. Between 88 to 90, the casual laborers were employed in the printing press.
Make use of the mic.
In 80 to 90, the casual laborers were employed in the government printing press.
1988 to 90?
Yes, madam. Now, in 1994, there was an interview and test.
1994. 94.
Yes.
But they were already employed.
They were casual employment.
How many?
There are 500. I am just on 105. This is 105.
Interview was in 1994. For what?
For regularization. As per the rule.
Which rule prescribes interview for regularization?
18(1)(b) of the printing press.
No, it is
such a rule.
Yes.
There is a rule, my lord.
At 74. I'm just not seeing it here, lordship.
There is a rule, 78 rule.
Interview by interview by whom?
Interview by the director.
Director interviews.
Yes.
Director printing press.
Yes, ma'am. Then, my lord, they were regularized.
All 105 were regularized.
All 105 were regularized.
This interview is under which rule?
Under that 18(4), your lordship can have that. Recruitment to class 4 posts. That's with rule 18.2 class 4 posts. Yes, ma'am.
Your page number?
Not, my page number is 11. Actually.
11.
Yes. I have got the my lord justice Francis.
Class 4. Yes.
Class 4. Here, my lord, all unskilled class 4 posts will be filled up by way of direct recruitment from the open market and so on. Now, your lordship can 4.
Yes.
IV. Preference will be given to the casual employees who have put in continuous service for more than 240 days, and such employees may not be ordinarily required to the face of the process of interview, test, and their selections will be made on the basis of their performance conducted on the sincerity. Let's kindly have that. Conduct, sincerity, aptitude, and regularity, etc.
Preference will be given to the casual employees who
240 days.
Continuous service of more than 240 days.
Yes.
Such employees may not be ordinarily required to face the process of interview and test, and their selection may be made on the basis of their performance, conduct, sincerity, aptitude, and regularity, etc.
Yes.
Maintained during their service period.
Yes. So now on the basis of that, in 1994, all the 5 were regularized. Now, all in a sudden, the government, lordship, you have that page 69 of the brief. That order was kept in abeyance, lordship.
On 8/9/94.
Yes, madam. On 7th April 1994.
7th April. When were you regularized?
On February and January of 1994. Lordship can have that 69. It will be page 69 of the brief.
February 1994.
Yes, madam. January and February.
January, February.
Yes.
That was kept in abeyance when?
On 7th of April 1994. May I just place, my lord, that.
Who kept it in abeyance?
Again, the director, it's director. But kindly, my lord, mark there they will continue to as casual helper in respect of the places of daily wages basis on 25 rupees per each working days from 8/4/1994 until further order. So there is no complete termination.
They will continue. Their wages were fixed.
Fixed. They are just reverted. So we challenge this thing that this
Reverted.
Yes, madam. They were initially regularized by all these orders. Your lordship can have 69 to be clarified.
So where is the reversion to which post?
Casual labor again.
This is the one. No,
This is your lordship.
status is altered.
No, my lord, we are regularized. We are regularized in the month of January.
Generally, in service law, reversion means from higher post
Yes, my lord.
or from
But
higher
actually-
pay, higher grade
Yes, my lord.
to the lower ones. But
Yes.
that is not the case.
That is not the case. They are regularized. That regularization was kept in abeyance.
On what ground they did it?
The impugned order doesn't say anything.
Doesn't say.
Anything. Now we assail this action by way of two way before the State Administrative Tribunal. The writ petition is arising out of one way where 10 numbers of people are there, and the other is accompanying way, which is 1378 of 1994. There 94 people are there. One was died by that time. So that comprises of whole 105. So in our case, the tribunal, the one decided case, the tribunal say that since the appointment is in excess of vacancy, therefore it cannot be regularized.
Yes.
Now that we have challenged here before your lordship.
But abeyance order does not say that.
The abeyance order doesn't say that. And we have categorically said that this he cannot do because he has to follow the process. Again, once we are entering into the rule book, the recruitment rule, then the process of recruitment has to be followed.
Yeah.
Then, my lord, we have filed this writ application. Now, in the writ application, they filed we have filed the RT document, the rejoinder of the directors. The lordship can remember that words that the regularization requirement is their performance conduct, sincerity, aptitude, and regularity.
Etc.
Yes, ma'am. Exactly that is what being the director said in the RT application query which we have made. Your lordship kindly have that. There are 4 in total. I'm just drawing your lordship to page 118.
No, sub-rule 4 or clause 4 of the rule.
Yes, madam.
Which you mentioned factors, no?
Yes, madam.
Who will assess this?
But that's the director because he is the employee.
There
He is the employer.
There is a committee who is to approve. There is a committee. The recruitment committee is there according to that rule.
Which is that section, subsection?
Recruitment and promotion. The rule 9, appointment and promotion.
We want to know whether he does it single or it's an institutional decision. If suppose regularization is institutional decision, then you may gain one more point now.
Yes.
In law.
Yes.
If regularization is by institutional decision, can it be placed in abeyance by a single authority? That question will arise. That may help you.
My lord, but here there is absolutely 18. There is no government opinion.
The chairman. There should be a committee of officers.
Yes.
And they have directed the regularization.
Committees to approve all the appointments for regularization.
No, can you read it? Read the rule.
Yes.
Give that rule book. No, perhaps you are not adverted to that rule position.
Hello.
Advert to entire rule position. That may help you.
I'm just carrying out the factual.
Now we have understood the case. Yes. These are not the Keshavananda parties. These are all service matters of run-of-the-mill cases. Now, our question is, where regularization is to be done by the director on the advice of a special committee, and it was done, can the director subsequently, unilaterally, without aid of the
Take a decision.
yes, that will be the question.
Yes.
Whether that question, perhaps that was not raised before the learned single judge at all.
No, before the tribunal.
Tribunal.
By the
Not
tri-
raised before the tribunal.
No, by the tribunal has given another justification.
Saying
They have given them.
in excess of.
In excess of, that's the reason.
That is the.
But that was not the case in the order of the director.
No, I'm coming. Let him submit, my lord. I'll come.
Now, Your Lordship, I'm drawing Your Lordship's attention to the director's positions, which we have received on the basis of the RTI. I just have to make one submission here. That all these employees who were appointed in 1994, notwithstanding this, they have been promoted. Their salary has been drawing as par. But subsequently, it has been withheld and other things. That's right. So,
These employees.
yes, man. These employees. My Lordship.
Slowly. One more thing. Slowly how to go now. See, you said in 1988-90 they were employed. They gained the entry to the service.
Yes, ma'am.
Correct?
Yes, ma'am.
105 employees.
Yes, ma'am.
Then in 1994, interview, etc., was conducted by the director,
Yes, ma'am.
stated by the committee,
Yes.
perhaps which you have not stated. And that was under exercise was under Rule 18.4.
Yes.
They were regularized
Yes.
in January, February 1994.
Yes.
In on a 17/4/94, your regularization order was kept in abeyance. Where is the power to keep it in abeyance is one thing. Where is the due process of law to keep it in abeyance in a wholesale way?
That's
The
exactly
director is not the mogul of the government.
That's exactly what we have raised. Now, my lord, I'm swing otherwise. Just that one. Lordship can have that page 118. The director's own letter to the government.
Saying
Page 118. This we have received from the
another director had come by that time.
my lord. There are many directors, in fact.
Many directors have come
And I'm directly drawing your lordship's attention to page 120.
120.
Yes, ma'am. There is a provision in the OGP requirement ethic where casual helper can be regularized. It's a fact that the above helpers have been working continuously for more than 25 years. They have been substantially contributing to the production. The government have been requested time and again for the regularization as the vacancy arose consequently. Some of them also promoted prior to receipt of the government order. Most of the production work are being undertaken by them and they are well acquainted with the work at hand. Their devotion to duty cannot be ruled out and they are indispensable manpower for productions of the printing work. Now, not only the only director, the other director also writes, my lord. That's the next page.
One more point you have left. Next point you have left.
My lord, the RSP, yes. So further to state that they are being paid salary at par with regular helpers for their promotions in RSP, RAS, and pensionary benefit are not paid as the case are sub judice against them.
They have rendered more than 25 years of continuous
service.
Have become overaged to be engaged anywhere else now. What do you say, Mr.?
In fact, many of them have died and almost all of the persons have attained the age of superannuation and they have already retired. Barely 10 to 15 persons are there. And these honorable court time and again ask them to file, and I'm drawing your lordship's attention to the order dated 24/11/2025. They have filed an affidavit pursuant to this honorable court's direction dated 7th of May 2025. Your lordship can have that. 7th of May affidavit. That and this order has categorically, your lordship can have that. The order dated 24th November 2025.
Go to 25 November. 24 November.
Yes, madam.
More than 30 years.
Yes. And here the government has given a proposal.
That may not be correct. More than 30 years may not be correct.
94.
No, but many have demitted office after attaining the age of superannuation.
Those have not demitted them. Anyway, lordship. 24, the government affidavit has been rejected and lordship.
In the affidavit, what they say in gist?
The affidavit, they say that in the future vacancy will give them.
No, that question will not arise because many of them have already, how many of them have retired?
Almost 90.
No, that will not, almost is a dangerous word.
Exactly, I'll get back actually.
And there is also another thing in page 121, which is a letter of the director to the government. Government, yes.
Yes, madam.
That also speaks that they were getting pay allowances, annual increment, like any other regular employees, hence promotion, SCP, and all other service benefits were allowed to them.
Yes.
Until receipt of government letter dated 6/11/2012, wherein questions were raised about such benefits. Such benefits having been denied to them since they were treated as regular employees
on the ground as described in paragraph 3.
So these letters must be with you also.
Yes, madam, that's 121. I am just carrying out that one after the other director is actually saying that regularize them, without them we cannot work. And even in the same line.
But essentially, if that abeyance order is settled,
Yes,
everything will follow.
yes, that's it.
Therefore, Mr. CEO, where is the power to keep it in abeyance?
My lord, Lordship may kindly look to the 78 rules, rule 9. Rule 9 of the 78. Which are government press. Government press in rule 9. Recruitment and promotion. Appointment and promotion committee.
It's about the committee.
Yes. The director, who is the appointing authority, will with respect to all non-gazetted industrial posts, will make appointment to such post by way of direct recruitment, internal promotion, and deputation from outside. He will be headed and guided by a committee of officers comprising of the following, namely director.
That's for direct recruitment.
Yes, and promotion. And promotion.
That's all. But under 18, rule applicable is 18.
My lord.
There is a rule 18, is a special provision.
Well, I'm coming there, my lord. The functions of the committee. The committee shall meet occasionally to discuss all matters relating to recruitment and promotion, etc. The secretary shall take initiative and issue formal notices to convene the meeting. He will issue agenda for the meeting and detailed notes on such items, such agenda.
That is for direct recruitment and promotion.
Promotion.
But there is another committee. Kindly see, same committee may be, but it has some different function under Rule 18.
Rule 18. That is recruitment to class 4 posts.
Yes, they are casual. All casual employees.
All the
helpers, they were helpers.
All regular vacancies will be duly notified into the local employment exchange from among the candidates duly sponsored by them. Selection shall be made after proper interview and test unless otherwise provided these rules. The candidate must be sufficiently literate, should knowing cycling, etc. The candidate should be will be appointed strictly on the basis of merit, judged through the above process of interview and test. Preference will be given to the casual employees.
This is special.
Who have put in continuous service of more than 240 days.
Yes.
Such employee may not be ordinarily required to face the process of interview and test. Their selection may be made on the basis of their performance, conduct, sincerity, aptitude, regularity, and maintained during their service period. Candidate passing printing alert, etc. Here, my lord, this rule 18 to me, what I
18.4 contemplates the existence of casual employees.
Here 9 sub rule 3. Rule 9 sub rule 3. The appointing authority will act upon the recommendation of the committee. In exigency of public service, the appointing authority may fill up posts in anticipation of approval of the committee by recording such proper reason. Majority opinion of the committee shall form recommendation of the committee. Note of disagreement or dissent should be properly recorded in minutes. Committee, everything is done by the committee.
Correct.
It is not individual action of the director.
That is not the case.
Yes, here is a case. My lord, Lordship may kindly
See,
impute order.
1 second.
Lordship may kindly have a
He
look
has
to the
been, let us see the order, impugned
Yes,
order.
impugned
Where is the
order.
abeyance order?
impugned order
At
is,
page 69.
my lord,
Six,
Page
No,
69,
no, sir.
69.
sorry.
69.
Lordship may kindly have a look to annexure 5. Annexure 5, page 81 of the brief.
Annexure 5.
Yes.
Service book.
No, no,
No order.
order of the tribunal.
Service book has been-
Order of the tribunal.
This page number?
81.
81. Cost title.
Yes.
Should you see the cost title?
Cost title is there, my lord.
Huh.
It's an order of the administrative tribunal's order, my lord.
That's all right.
Yes.
Now, the tribunal, why tribunal could deny, how tribunal could deny the relief to the, we are asking a simple question.
My lord, my lord,
Question is, if you permit us,
my lord.
question is,
Paragraph.
the regularization order was passed in January, February 1984 in 2 groups.
Yes.
Who passed the order?
The director has passed the order being the appointing authority. He is to pass this order in consultation with the committee.
Is it your case that he had not
Consulted the committee.
That is it your case?
Yes.
Go to the
Lordship.
the abeyance order dated 17/4/1994. That is not the text.
No reason has been assigned.
Nothing. Your director thought he is a Mughal. If not Muhammad bin Taghlaq.
Lordship, can I place the order passed by the tribunal relevant?
Yes, very well. What is the reasoning of the tribunal?
Reason said that
Your advocate general had undertaken to come out with the
earlier,
statistical data
yes.
pursuant to the order of the division coordinate bench. Because most of them have already demitted office after attaining the age of superannuation. Only few are remaining, frugal few.
With due apology, I am not aware of that.
Order, the 24/11/2024 order, before I came to your court,
24/11.
1994 order. It's a very elaborate order.
2025.
25 order.
25.
No, 24/11/20, you are right. 24/11/2025 order.
25.
There are several orders on this point, exactly by various coordinate bench. And each time
This order is very elaborate. Because this order was made after looking into your affidavit also. That reflects another order dated 17/5/2023, where they say, kindly read this. The existing petitioners, if are to be regularized with prospective effect in the post of Group D, and they will be allowed the initial pay of the level 1 of the pay matrix. But on the other hand, as the petitioners are drawing higher pay at present due to continuous service as per interim order of the Honorable Court. The petition numbers 2 to 5 of the present petition, who are at present continuous in Group C industrial post on promotion, are to be considered for regulation of service with the prospective effect in the Group D base list, by which their present salary will be substantially reduced. The petitioners, by additional affidavit dated so and so, have prayed relief for regularization with notional effect from the they are joining 94 as regular helpers in order to claim pensionary benefits, which is not admissible since their appointment have been declared illegal by the learned OAT or so and so, so and so. How it will be illegal?
It is not
For
illegal.
such a long, how can that be illegal? Your
No,
rule
it is not
18.4 itself provides for all that.
It is not illegal, but the tribunal has.
The tribunal has gone beyond its scope.
It appears no tribunal has gone on jurisprudential reasoning because there is no order and therefore it is illegal.
That is also not the plea.
That is not the plea. Now, because the order of the director does not give a reason.
My lord.
It is an order without reason. Giving reason is one of the requirements of principles of natural justice. So if an order is passed in violation of principles of natural justice, there are judgments which say they are void ab initio to that level also, because natural justice are read into Article 14.
Yes.
Kranti associates.
If that is so, how does where is the treatment of the subject by the tribunal?
No, tribunal.
The tribunal has treated the matter as if the presiding officer was a first-year law student.
No, he is not a law student.
He is not a law student also.
That's the problem.
That is the problem.
The person who appointed and the person who judged, they are in the same batch IPS.
Batch rivalry also.
That's exactly the
These
case.
people will be victimized.
That is exactly the
Let's say we are allowing this.
My lord, lordship will allow, but give me some time so that a week's time only I will take.
Matter having been heard
I
at
talk to
length,
them
is reluctantly adjourned by 1 week for
Yes.
further hearing. Okay. No, this is the order lacks elements of justice. A law also. Law also.
Fix a date so that people can be people will get us.
After 11th, we'll fix this. 11th of February.
Yes.
I'm likely to be absent for that particular period.
Yes.
That's the reason. For this matter, for further hearing before this bench itself on
I'm not 11, 13, 15, 15.
15.
I will come with some.
Come out, some policy how to come out. Instead of we imposing our view on you,
Yes.
you only can be reasonable. Very well, all this has happened. Many have already retired in the evening of their lives. Something we will do. Anyway, you are giving so much freebies to so many voters, etc. At least these are the people who have served the state. Yes.
Item 12. Section 57 of 2024.
So, in this case, affidavit is required to be filed. Person by Lord's direction, that is positively, such affidavit should be filed on next date. I not pass the order. But the officer is not to the affidavit until now. This is literal benefit and other things has not been held up for.
You want time? Pass over.
After lunch.
After lunch. Pass over.
Item 13, WPC 1779 of 2026.
If I may please, my lords.
Yes, brother.
My lords, last order.
We had directed payment, depositing that amount. Have you deposited now?
My lords.
Who appears for the other side?
I am not of it.
Yeah. What he says is, because of is it 29 order it was?
No, that is a different case. That is posted to 2nd of April.
Okay. I was under that one. Now this is a different matter. Bank matter.
Bank matter, your lords.
Okay.
IA 1259, there was an order on 19.
Months, 19th of
19-1.
What is the amount due, brother?
My lord, now day after, according to me, it was less than 20 lakhs, because of which your lordships had asked me 50%, 10 lakhs. I have made the deposit, my lords, in 2 installments. They have to answer. What is the amount due?
On 19 January, lordship directed that the auction shall continue, but the sale shall not be confirmed. And my instruction that the auction is successful and the 25% of the bid amount has been deposited, but the sale has not been confirmed because of the loss.
Because of this one.
Yes.
So auction would be subject to, he insisted it should be made subject to. We did not say those words because section 52 will come in the way. 52 says it is a risk
Yes. And he has also preferred the essay before the learned tribunal, that is essay number 23 of 2025. That is pending.
Well, while conducting the auction, did you tell the participants that there is such an order of the High Court?
Prior to that, my lord, he has filed the essay.
We are asking a question.
Yes.
As on the date the auction was held,
Yes.
did you tell to the participants that there is a High Court order like this?
No. By that time, my lord, it was not there.
There was no order by that time.
No, it was.
There was there.
Yes, it was.
Auction was subsequently.
You can see the.
When the order was made, brother?
19/1/2026.
19/1/26.
And the auction was held on 21/1/2026.
So there was an order
Yes.
by that time.
Yes, my lord.
Did you circulate this order amongst the participants in the auction?
That
That will be fraud on the auction buyers then.
Your Lordship's order is very clear, my lord.
Saying
That the auction shall be held.
correct.
The sale shall not confirm.
Correct.
That is
Did you tell them? See, there is an order like this. So therefore, you have to make a wise decision for participation in the auction. That you did not tell the auction buyers. So somehow you want to sell the property without
No,
any.
that is not, because we have not confirmed the sale as per Lordship direction.
Right. But you were supposed to announce this. Read that particular rule. Everything has to be disclosed to them. Section 52 of the Transfer of Property Act applies to auction. List pendants applies to auction. And now they will be in darkness. Therefore, he insisted other day. You write in your order that auction will be subject to outcome of this one. We thought you would do that job. Therefore, he rightly insisted other day.
Because by this time the order was passed, my lord, the bank has not appeared.
You give the name of the auctioneers now.
Yes. The bank has not appeared by the time this order was
But
passed.
this order was produced before you. This order was produced before you, much before the auction.
That I have to take issue of when, my lord, this order was produced to the bank. My lord.
Okay. So
because the 19th your lordship passed the order, on 21, my lord,
yes,
the
2 days after the
auction was conducted.
Correct.
Yes, my lord. And my response submission is that the essay is pending.
Essay is against what?
Essay is, my lord, the previous auction sale which was, my lord, failed. And your lordship's order is there, my lord.
Yeah, we are just thinking.
Yes, ma'am.
You file a essay and our order will continue. Yes, because we did not tell the auction buyers. Our interim order will continue. You file a essay. Essay will decide all contentions which you have taken before us.
Essay is already filed.
Yes.
No, he has filed in respect of earlier order.
Earlier option. Now it is.
Now he has to file essay. Let him, what is the period for the limitation period?
My lord, 45 days.
45 days. Now, anyway, it will be within 45.
No, my lord, it cannot.
In the same essay, you can raise these.
In the pending essay.
Yes.
In the same, my lord, I have to amend it.
You have to amend. Permit that.
Why to have another?
Your lordship, my
Right.
Yes. Your lordship, my
Challenge is to the coercive action of recovery constituted under the provisions of Surface Act 2002. First one. The counsel for the petitioner draws our attention to the interim order granted on 19/1/2026, which reads as under. Next paragraph. After service of notice, the panel counsel appears for the OPs and submits that in terms of the interim order dated 19/1/2026, auction has been held and that sale has not been confirmed. First, he does not dispute version of the petitioner that he has already deposited a sum of rupees 10 lakh as conditioned in the interim order. First off, the said interim order interdicted confirmation of the auction, should it take place as scheduled. First off, the panel council fairly submits, and with this counsel for the petitioner fairly agrees, and we also share the same view that in the petitioner's pending essay number 23 of 2025,
No, that has been filed by the wife. It is not the petition. The petitioner's wife has filed the essay.
Petitioner's wife, filed by petitioner's wife, all the contentions taken up in the petition can be urged by filing an appropriate application for amendment. And till the said essay is heard and disposed of on merits, the interim order granted by us shall continue. First of all, they also tell us that all contentions of the party should be kept open for being considered by the DR. First of all, we agree. Next paragraph. Ordered accordingly and writ petition is disposed of.
Disposed of within a stipulated time.
Essay to be heard and decided within an outer limit of 3 months. 3 months.
Grateful.
You rightly insisted that we should write that the auction will be subject to outcome at said.
Yes, but that is now posted to 2nd of April.
Okay. Anyway, all these content.
I will. Grateful.
Thoughts.
Item 14, WPC 8313 of 2026.
Brother, you have to make auction buyers also party safely. One sentence you add back. It is open to the petitioner to seek implement of the auction buyers of the subject property in the fitness of this. Ordered accordingly, petition. Put it above.
You will give the name.
You furnish the names.
Yes.
In that connection, the bank shall furnish the names of auction buyers to the petitioner on a war footing. Okay. Okay. Next.
Item 14, WPC 8313 of 2026.
This is the guarantee. On 18/3/2026, I have already solved a copy. My learned friend is also appearing for the
What are your financial credentials?
He is not an income tax assessee, and he has, except this homestead land, he has no other lands. And he has also no fixed deposit, debentures, mutual funds.
You have said it on affidavit now.
And affidavit, so I have prepared an affidavit, but since he has not come, I have not sworn. Possibly taken tomorrow or affidavit.
So when the auction purchasing is
30th, and he also asks that the loanee is the father. He has taken a loan. In the meanwhile, due to non-renewal of a theft has been taken place in the clothes store, but due to non-renewal of the insurance coverage, the loanee has filed a consumer dispute case before the district court where 6 lakh has been awarded. And thereafter, the bank has preferred an appeal. Appeal is pending. While the matter stood, this sale notice was issued in favor of the petitioner, and your lordship kindly see, they have taken possession 2013.
Sell notice?
Sale notice and annexure 2.
No. In favor?
In favor of and the property which has been mortgaged by the
Is now put to sell.
put to sale.
So the date of possession is 2015. After
4,61,591.
5 lakh. You can see as on 31st December 2012.
Now how much it will be?
How much your lordship directed them to calculate?
How much money is due?
It is now around my lord 60 lakhs from around my lord.
60 lakhs.
60 lakh. How? 4 lakh odd was in 2012.
That is my lord the 11 lakhs as per the 13th notice. Lord, as on the date of demand notice.
Total amount 4,62,591. Date of possession 1/10/2015. Date of demand notice 25 on column number 1, 2, 3 at page 16.
Now, how whether calculator has gone crazy in the bank? How this money? How it will be? It is 4,52,591.50 say as on 12/12/2012.
12 million.
From 2012 to 2026. How calculation takes place?
In general, I shall produce the statement of account. That there, my lord, it is compounded the interest.
Compounded.
Yes.
What is the compounding rate and compounding period?
My lord, the rate of interest, my lord.
What is this money? This is for housing loan or what?
CC loan.
CC loan, my lord. CC loan.
Commercial loan.
Commercial loan.
8,50,000 in the year 2005, my lord.
No. 4,52,591.50 as on 31/12/2012.
Yes.
Kindly come to your sale notice annexure 2.
Yes.
This is dated the 21/2/2026. Now, how 18,86,000?
4 lakhs.
4,62,591. How, where from you are telling your figure?
Yes, my lord. The contractual rate of interest, my lord, with monthly rates.
What is your notice? Amount is specified in your
Yes.
notice. Notice is of 21 February 2026. That notice says how much money?
That is, my lord, as on interest calculated up to, my lord, 2012.
Yes, 31/12/2012.
Yes, my lord.
With the rate of interest, what is the rate of interest?
Recoverable amount is also mentioned, brother. Kindly come to third paragraph or third column of the notice. Annexure 2, page 16. In your bank, perhaps clocks, calendars, and calculators do not work.
That is the reserve price, my lord.
No.
8,86,000.
No, recoverable amount, third column.
With interest as on this time. With interest.
Yes. Recover. That is 4,62,000.
And out of this, the amount that he has paid has
Interest as
to
on 30.
be deducted again. Minus
The amount paid.
any amount, any repayment amount. So this is also not the final amount.
I shall produce the, my lord, total detailed statement of accounts. But wherein, my lord, the rate of interest as well as the, my lord, the
But don't sell that house then. Don't sell the property. You pay that 4,52,000, 12,060.
62,000.
50%.
What 50?
50%, 2,20,000.
What happens? No, more money has to be paid by you.
That amount
But
is
it
of
appears
12.
they have some crazy calculator they are working with.
And this amount is of 2012.
This is of 2012.
yes.
And now also you say the recoverable amount is 4,62,591.
That is
As on 31/12/2012.
Yes.
Let them pay. It will be 31/12/2012 means how much it will be? What is the rate of interest?
Details I will submit, my lord. The rate of interest and the exact, my lord, calculation.
Now what is the action they are taking?
They have not taken action. This is put the auction fixed on 30th of
30th.
30th of
March.
April.
March.
You pay 30% of the amount along with interest. Have you filed any INO?
Yes, I filed a pension application.
And you go before the tribunal. Why we have to examine all those things? Tribunal's case.
Kindly see the facts. There is a dissension between the father and son.
That is in every house. In every house, right from the days of Mahabharata, Ramayana, the 6
and 6 lakh has been awarded in favor of the father. That has not been paid by them because non-renewal policy of that law storement.
The entire this contention with the bank, you cannot take up that contention in DRT. And we are a super DRT now. We also cannot take up that contention. You go before the DRT. We keep open all the contentions. You file the DRT 17 application and seek redressal.
The amount is 4,62,000.
That is in 2012.
Unless they produce the statement of account.
If they produce it, will you pay it now? But then why not they produce?
Unless more than 10 lakhs, this is 4,62,000.
It will be more than not 10. It will be more than 20. But you are saying 68.
63.
63. Where is the memo of calculation? No, you have to share with him. No? You have to share everything. You are not assisting the proper court at all. We are told the petition seeks a redressal against the compulsive recovery proceedings constituted under the provisions of the SARFAESI Act 2002. First of all, Learned Counsel for the petitioners draws our attention to Annexure 2, which is a sale notice for the concerning the security property, which mentioned that he was that the outstanding loan was 4,62,591.50 as on 31/12/2012. First off, records reveal that it is a commercial loan and therefore commercial rates of interest would obtain. First off, Learned Counsel for the petitioner submits that unless the sale notice is stayed, the security property would be put to auction, and that would cause manifest injustice to his client, who is ready and willing to show his bona fide by making a payment of reasonable sum of the outstanding money. First off, this is fair. Next paragraph. In the above circumstances, the application in IN number 9 so supported by affidavit having been favored, the scheduled auction shall be deferred till next date of hearing, subject to petitioner paying 30% of the outstanding money to the bank in 3 equalized fortnightly installments. Okay? Fortnightly installment. Failing which, petition itself runs the risk of dismissal. First, all this matter after 2 weeks to ascertain payment of first installment. The installmental value will depend upon the statement of account to be furnished by the bank to the petitioner on a warfoot. Call after 2 weeks. Next.
Item 15, Contempt 440/2026.
Item 15, may I please, my lords? Lords, I may be excused that I am appearing through virtual mode, my lords, not being physically present to assist, my lords. Lords, on the last occasion that is
in the matter.
Yes, my lord.
What have you done?
We have.
What was the order? What you have done?
Lordship.
Lords, order dated 18/12/2024.
Well,
Wait, 1 second.
18/12.
Are you from Delhi? Are you from Delhi?
No, my lords.
Okay, all right. Okay.
My lord.
Yes.
18/12/2024, your lordship disposed of the writ petition with a direction considering the submissions made by the Learned Counsel for the respective parties without expressing any opinion.
On representation, decision has to be taken.
My lord.
What was the representation?
My lord, we have taken the decision on 19/2/2026. I have filed a compliance, your lordship.
On what period you ought to have done that?
It will have to within 2 weeks.
3 months.
My lord, within 3. Taking the decision, there shall be communication to the parties in 3 months.
Whether you committed, whether it is done within 3 months?
19/2/2026.
It is not up.
No,
it
is not within
2026.
I beg unconditional apology.
No, that makes no sense. We are not here to buy your apology.
My lord,
don't apologize at all to us. We don't want your apology at all. How many months it has taken? Per month, 10,000. How much money?
My lord, here is a case, my lord. It is not that if consumer protections, members of the Consumer Protection Act, they have, one of the member have filed.
No, what is the representation?
The representation was that
for revised scale of payments.
For revised scale of pay, they had not
My lord.
Representation is dated what?
So he has relieved from the post with effect from 16/1/2025.
Date of representation, we are asking.
Date of representation, it is.
What is the date, brother?
My lords, date of representation is
Dated 18/4/2024.
yes, my lords.
4/24.
24.
Date
The
of
petition-
judgment?
Date of judgment is, my lord, it is 18/12/2024.
How many months of delay?
Date of
And
judgment.
who is the officer who took this? Who is that secretary who took the decision? This secretary has no respect for the court's order at all.
My lord,
He
that-
only, in affidavit, he will say, we have great respect, the judges are great, they come from heaven, we hold them as gods, etc.
My lord,
But
they
what
have-
we should do with all our
My lord,
postings?
while disposing of the representation, my lord, they have said that the law department opined on applicability of revised pay structure on judicial
When
officials.
matter was sent to the law department?
As per resolution dated, that date is not there with.
No, we are not, we are imposing cost of rupees, 1 lakh rupees.
My lord, when pursuant to the finance department, my lord,
Take note.
Lordship may kindly,
Yes.
kindly peruse, I'm placing the,
You place it. What we should do? Court has said, within this
My lord.
period you should do. That has not been done. In everything, apology is no. We don't. Who wants your apology? We only will tell apology, our apology for imposing costs.
my lord,
What
Lordship may,
citizen should do.
Lordship may, pursuant to the said order dated 19/5/2025, passed by the Honorable Supreme Court in WP Civil number so and so, the matter was endorsed to the law department seeking views as to whether the said order dated 19/5/2025 should be implemented or the department should proceed with an attempted amendment to salary rules supra. While the views of the law department is awaited, another judgment dated 21/5/2025 was passed by the Honorable Supreme Court in Ganesh Kumar Rajesh Rao Salukar and others versus Mahesh Chandra so and so with regard to selection of adjudicators of
That was on which date?
That was judgment dated 21/5/2025. Whereas
That question will not arise because
my lord,
18/12/2024.
my lord,
3 months will be 17/3/2024.
my lord,
Rest of the things all happened, including Pralaya, etc., are irrelevant.
my lord, whereas after obtaining the views of the law department on the order dated 19/5/2025, wherein the law department advised to act in conformity with the said order dated 19/5/2025 with prompt and presuming any further amendment to the CP salary rules that may be warranted, views of the new recruitment rules to be framed pursuant to the judgment dated 21/5/2025 of the Apex Court, Honorable Apex Court, particularly in terms of the categories of the adjudicators, their qualifications, tenure of office, etc. The matter has again been referred to the law department for views on whether the order dated 19/5/2025 be implemented or further communications from the Government of India regarding framing of new rules supra be awaited to avoid probable repeated amendments of the Orissa Consumer Protection Salary Rules 2020. Views of this in this regard are still awaited. In this way, he has disposed of the representation given by the
Question is,
petitioner.
3 months was given.
Yes.
What all happened is on 19/5/25, 21/5/2025. How it is relevant?
My lord.
Why
My lordship-
within 3 months things did not happen? Why secretaries of the department are harassing the common people?
My lord, lordship have given me 3 months of date of production of the certificate, 3 months time, and it will be communicated to them 2 weeks thereafter.
When it was produced, order was produced before you.
24th of January 2025, my lords.
24 January you had produced.
Yes, my lords. Your lordship may come to contempt petition running page number 21. They have received it.
How many months of delay, brother, totally?
My lords, if your lordship may allow me 2 minutes time, my lords. Lords, this is a case where they are not saying that I am not entitled, my lords. They have kept it pending till the filing of contempt application, my lords.
When did you inform them? When did you send this letter to they were ordered to the
24th of January, they have received it.
Submission of the order. They submitted the order to the department. Order was made on 18/12/2024.
My lords. Thereafter, there was some typographical error for which I had filed interim application, my lords, on 6/1/2025 and 15/1/2025. Pursuant to that, my lords, I have communicated the said order and they have acknowledged received the order on 24th January 2025.
Yes, 2025, correct.
And my
24/1/2025 rectified order was submitted.
Yes.
From 24/1, 3 months will be 23/4/2025.
My lord. Yes.
Correct.
Yes.
It may not be that also, or it may be roughly because February will be 28. Even if it is taken, that will be 23 because March will be 31st.
My lord.
Taking that one. You have taken how much time? You have decided 19 to 2026.
My lord. Yes.
When did you send that
On the same day.
to him?
To him on the same day.
How it was sent? Have you received the order, brother?
My lords, my lords.
The order now.
My lords, I have received, but your lordship may just have a glance to my date of filing of the
When
contempt
did you receive
application.
it? When did you receive it?
You received the order from whom and how?
My lords, the order was
In the memo, it was communicated to him by
my lords, 19 to 2026 the order, and I have received on 23.
20. 23.
My lord, so far as my instructions are concerned. 23-2.
How much will be the delay?
My lords,
Who is the officer who passed that order? Who is that secretary? It appears secretary thinks himself too much. We'll cut him to the size now. Many secretaries have to be cut to size in your government. We'll do that. Though we are not surgeons, we know how to do it with our pen. Take down. In complainants WP number 18/12/2020, number 31694 of 2024, a coordinate bench of this court had entered the judgment dated 18/12/2024, which reads, operative portion of which reads as under para 6. Next paragraph. There was some rectification sought for at the hands of the bench, and that was accordingly granted on 15/1/2025. First off, copy of the order was presented to the authority who had to take the decision on the subject of presentation on 24/1/24 January 2025.
24th of January 2025.
First term. The nothing having been done within the time stipulated by the coordinate bench, this complaint of contempt of the court has been presented. First term. Next paragraph. After service of notice, the contemners having entered appearance. How many contemners?
No, it's only one.
The contemner having entered appearance to the learned AGA has placed on has filed a compliance affidavit.
Yes.
Dated
Compliance affidavit dated 23/2026.
2020 March 2026, telling the court that the subject representation has been considered and rejected.
No, we have not rejected.
Considered.
Have been considered, and the order kept pending is still awaited. Decisions of the government is still awaited because time and again the law is changing. So we are waiting for that.
To the effect that
Supreme Court's order, we have taken views.
New decision is being awaited at the hands of the government.
Yes.
In view of certain judgments of the apex court coming in the meanwhile. First off.
To avoid repeated amendment, we are waiting.
This decision, Kamal Learned AGA submits, is taken to avoid repetitive amendments to the subject, the extant rules. First off, next paragraph. Having heard learned counsel for the parties and having perused the complaint papers along with the compliance affidavit, we are dropping the subject proceedings complaint with the cost column in as well as the cost column for the following reasons. First of all, 1, the coordinate bench had disposed of the subject writ petition of the complainant on 19/2/2026. First off, rectification of the order was granted on 15/1/2020. 15/1/2025. Was disposed of on 18/4/1824. And rectification as sought for was granted on 15/1/2025. First, the order copy was submitted to the jurisdictional authority for taking decision, on 24/1/2025. First, no decision was taken despite the long lapse of time. First off, a decision is now taken on 19/2/2026, offering irrelevant things as the justification for the delay. First off, which paragraph you read, Mr.
In the compliance manual, last paragraph.
In the compliance affidavit, the following paragraphs read as under. Next paragraph.
Where is?
This is a case of criminal brooking of delay by the contemptor, who has taken belatedly the decision on 19/2/2026, and a copy thereof is served on the petition complainant on 23 February 2026. First one. The conduct of the contemptor is contumacious, to say the least. It exhibits scant respect for the orders of the constitutional court, if no respect at all. First off, that cannot go unscathed at our hands. First off, such an attitude has to be curbed by iron hand, by making the contemptor to pay heavily from his pocket. First off, next paragraph. In the above circumstances,
My lord, can I pray, my lord?
proceedings are dropped. the contemner shall pay a sum of rupees 1 lakh to the complainant from his pocket for the criminal delay proved in the matter within 4 weeks, failing which additional sum of rupees 500 shall be payable for a day's delay for the first month and rupees 1,000 for the days next following. First term. Next paragraph. It is open to the complainant to lay a challenge to the representation in question, the compliance order in question, dated 19/2/2026, elsewhere in accordance with first term. In that connection, all contentions are kept open.
I'm grateful.
Item 18, my learned seniors are there waiting.
Yes.
So
we'll take it lunch.
On behalf of the state, may I pray for next week?
Why? What is the ground? Already it was adjourned earlier.
Yes, it was earlier. The interim order was continued. AG is to address your lordship that election matter status quo is there also.
No,
that will continue.
No, that's it. Yes. Covered judgment.
My lord.
Just have you shown it to you?
My lord, up to 105, this is in the board. Other matters is yet to come. So let him.
You just examine.
Exactly.
If it is there,
Exactly.
don't worry about the serial number.
Okay.
If they are covered, we can go reduce dependency. That's required, no? Just look into, give copy to him.
My lord.
Just give him. Afterwards, we'll call it. Okay?
My lord, I may be, pardon me, Lord, I am not virtually here.
Yes, Mr. Agent.
Item number, my lord, 18, 17 or 18. It's a cooperative matter.
18 minutes.
18.
18. 18, my lord, by operation of law, the incumbent has already incurred disqualification. So it's a finding of fact by the Honorable Single Judge. So the other side was pressing for hearing today. In fact, I have an afternoon flight. So physically, it requires some time, my lord. Because
when will you have it?
My lord, 1 week after, any day convenient to the other side. It is, my lord, long since it is there.
I have my regards for the London Advocate General.
No, I am not. See, I thought that it will be reaching before long.
With great respect.
I have a 4:30 flight. I have to leave Qatar.
No, right. We'll take up. Is it all right for you?
No,
right.
Take up physically, not physically. I want to.
Not necessary. You argue on online only.
It's a written mail, there is a single judge judgment. The question is very short. If person will not by, if your lordship would look at the disqualification clause,
that one,
section 28.
Yes.
Item 18.
Section 20. Lord, your lordship may kindly turn to the Orissa Cooperative Societies Act.
Who is the appellant?
The other side is the appellant.
Fine. Cooperative matters will not. I can very humbly say fairly conversant with cooperative law of several states. Yes.
Right. Your lordship is conversant in all branches of law. Why cooperative?
That's a very lavish compliment. Yes. Yes, Mr. Rathore, tell me.
Yes, but if we find there are two appeals. One is writ appeal 365 of 2025 and other is 366 of 2025.
What are those applications?
Yes, ma'am.
1358, 1359.
etc.
There are two writ petitions for the Honorable Single Judge. One writ petition challenging the order of disqualification passed under section 28 3P of the Odisha Cooperative Society Act, passed by the registrar ipso facto, directly by the registrar directing that you are disqualified. Second is
Disqualification from being a member of the management or member of the society itself?
both.
No, management.
Management.
Disqualification from the membership means it affects the root of the.
No. He cannot be no person. Starts with no.
Membership doesn't go. Membership, anybody can become a member. But to become a member of the committee, there are certain qualifications and disqualifications like RPI. If somebody is
Mr. Rato.
Right.
Yeah.
No, the disqualification order was subsequent to a suspension order is passed almost on the same ground that the president is disqualified. Therefore, the elected committee of management is also suspended under section 32(7) of the Cooperative. So there are two orders challenged before the Honorable Single.
Yes.
Now, the Honorable Single Judge has dealt with the disqualification matter in the improved judgment. I'll take your lordship to the merits. Now, after having dealt with the disqualification matter on section 28(3)P, he says, Honorable Single Judge says that the second matter is also automatically dismissed. Second is suspension of the committee, for which there is a provision 32(7) of the Act. There, on the question of suspension, you will have to form an opinion on the facts. Those are the subject matter that has to, they were challenged before the Honorable Single Judge on the grounds available.
Yeah.
But the Honorable Single Judge, in the second matter, probably Mr. Kanungo is appearing. Second matter, he will argue that has not been at all considered merely because the first matter is dismissed, second matter is dismissed without assigning any reasons. So let me concentrate on the first matter. Now, your lordship says.
What is the legal lacuna in this order?
Yes, legal lacuna. But disqualification of a member or a elected representative, if your lordship will see section 28(3)P. One second. Section 28(3) first, your lordship, see Odisha Cooperative Society Act.
Yes. Mr. Acharya, what time we have to fly?
I have an evening flight, but before that, there is a meeting of the Water Dispute Tribunal. I have to attend that and take the flight. There is no issue if they have started, let them continue. I'll manage.
No problem.
By 5, I have a meeting in Secretariat.
5. Before that, we will complete this hearing at least. Yes.
Now, 28(3), your lordship may kindly see. No individual shall, it's a Cooperative Society Act. No individual shall, whether by himself or as a representative of the society, be eligible for being chosen or for continuing as a member or of the president
or office bearer of
vice president of a committee of a society if he, my lords may skip over all this, but everything is mentioned here, everything, committee, president, secretary, member, everything. Then lords may straightway come to P, has more than 2 children. P. Has more than 2 children. Then provided that then nothing in this clause apply to a person who has more than 2 children as on first day of January 1995 or as the case may be within a period of 1 year of the said date unless such person begets an additional child, this is not applicable. Now, if he has more than 2 children, he is disqualified to be a member of Soldier. Now, the petitioner on the basis of provisions available in the statute got elected and he is also elected as a president of the.
Now, what is the tenure began when?
The tenure is 2022.
22 to?
It is up to 27, 5 years. Note for कुछ more kindly see, Manu.
13/7/2022.
13/7/22.
Yes.
So it began with 14/7/2022.
Lord petitioner elected on 26/2/2022.
26/2.
Yes. If your lordship has got the writ petition, that is running page 97 of the writ petition.
Yes.
Lordship may kindly see.
97 of
No, disqualification is incurred on what ground?
more than 2 children.
More than 2 children.
2 children. That is not the ground on which that order your lordship will find.
Is it whether your client has got more than 2 children or not?
No, absolutely not. There has been adjudication in respect of the petitioner's wife itself before the tribunal, the cooperative tribunal. And there has been an adjudication in respect of petitioner's wife that the disputed child doesn't belong to the petitioner and his wife.
To whom it belongs?
To the brother of the petitioner. There has been an adjudication that has attained finality.
Adjudication
by the election, by the cooperative tribunal. The reason being, why I am before your lordship over this judgment, Lord, it's a question of disqualification, and this itself is an election dispute. This could not have been decided by the registered cooperative society in exercise of power on section 28(3)(p). This being an election, earlier also on this issue, parties have approached the cooperative tribunal raising an election dispute. And your lordship will see what they primarily, before I take your lordship to other issues, the seminal issue that is here is the Honorable Single Judge gives a finding that since the cooperative tribunal presiding officer is not there and not functioning, I take over the jurisdiction of the tribunal and under 226 I pass the order.
But there is one judgment of the apex court.
Yes, apex court
gives that power to the writ court. Kalinga Tubes versus Swine.
But I'll cite judgments being an election dispute. But this could not have been done under Article 226.
I'm sorry, Lord, I'm interrupting. It was their writ petition. They invoked the jurisdiction of the Honorable Single Judge.
Maybe.
I'm supporting the state here.
Then you finish it.
No, my lord, this submission may not be tenable because they had themselves invoked the Honorable Single Judge's order.
Let us see, Mr. Ratho, let's complete and then hear you out. Yes, Mr. Ratho.
Yes. Now, your lordship may see, but I'll first take your lordship to the provisions of.
In your writ petition, what you had challenged?
Lord, we challenged the order passed by the registered cooperative society disqualifying me on the ground of jurisdiction, saying that registered cooperative society has no jurisdiction to decide this.
Because it lies with the tribunal.
Tribunal. It's an election dispute.
What are the, let us see the scope of power given to the ARCS.
Yes, kindly see. Kindly see. There is no power given in the act.
Let us see.
Kindly see. Kindly see 28(3)(p). Sorry. Yes.
Which section?
Lord, it is section 28(3)(p) only, the disqualification, that's all. Kindly see. The provision begins like this.
No individual shall.
No individual shall, whether by himself or as a representative of the society, be eligible for being chosen or for continuing as a member of the society, of the committee, of a society if these are the disqualifications.
And two persons is, 2 sons is where? 2 children.
P for Puri.
More than 2 children, it starts.
If your lordship is holding Mr. Burma's book, then it would be at page 90.
So he had 2 children before 1995.
Right. That is what the allegation was. There was
do you admit that?
No.
No children
Not at all.
You have no children at all?
I'll cite from materials. Documents I'll cite. Not those.
We are asking.
You don't know.
You have no children at all?
No, I have 2 children. I'm sorry.
You have 2 children, not
2 children, not the third after the cut-off date.
The third child is yours or not is the issue.
That's the issue.
Under section 28, right. Who is the authority who passes the order?
Yes, who is the authority? Now I'll take your lordship to section 67 because I have my client is elected, my lord.
Now the election is running page 96 of the writ petition before the single judge, my lords may kindly see. 2D2. Yes, kindly see. 96, my lords may kindly see. Running page 96.
Running page 96.
Yes, this is the election notification of mine. Election officer has notified this. Election to the office of President, Capital Cooperative Bank, Asarnagar, Bhubaneswar, Vishwaranjan Mahanti. Number of valid votes polled by the candidate, 09.
Reference to the writ petition.
Before the honorable single judge, ma'am. Lordships are having that, no?
No, that section you wanted to read, na?
No, I am showing the document by which I was elected.
No, we are not on that.
On that. Then your lordship may see section 67.
No, that.
But I contain that
Constitution of Power, 67A.
67B.
B. Powers of Tribunal.
Yes, then I'll take your lordship to rule 57.
This is B.
67B, notwithstanding anything. Lordship may kindly see. Lordship got it?
Yes.
Notwithstanding
any office bearer
contained in any law for the timing in force, any dispute arising in connection with election of any office bearer of a society, or the disciplinary action taken by a society or its committee against any paid servant of the society who is not a workman within the meaning of clause A subsection 2 of industrial dispute clause shall be referred to the tribunal in the manner and which within the period prescribed in that.
We have read it. You mean to say that issue can be decided only by the tribunal?
By the tribunal.
Where is the election dispute?
Nobody has raised the election dispute.
But then why matter should go to the tribunal?
Registrar passed the order of disqualifying me. He has no authority.
Where are the powers of the registrar? Which section?
Right.
It is not an election dispute.
It is an election dispute.
It can be an election. It can be an election dispute. It may be.
Yes.
Two authorities may exercise concurrent power.
But if your lordship finds in the statute, that registrar is empowered to determine the question of disqualification, then your lordship view of two concurrent authorities is correct. But in my humble opinion, in the entire framework of Cooperative Societies Act, registrar of cooperative societies has not been empowered to determine the issue of disqualification.
Let us see how these powers are decided.
Kindly see the order passed by the Register of Cooperative Society.
No.
Power of the register
from the statute book.
I don't find any power. Then your lordship
those who say that he has power has to show that.
Yes, let them show.
Two submissions.
Kindly see.
Number one is he lacks competence.
The registrar has no jurisdiction to decide the issue of disqualification.
Therefore, in so many words you are saying, I said he lacks competence. 3 words. Maybe if we can use 100 and odd words, it's also different. Number 2, assuming there is competence, there is no legal evidence to come to a conclusion that he has begotten one more.
But there is an inquiry. He has taken up an inquiry. Based on an FIR,
if he has no power,
then
it will not go to that.
That's the point. Kindly see the order of, before that, your lordship, would I like to show the order of disqualification?
Before that, can we examine whether the registrar has...
Definitely, my lords.
Who says he has power?
Well, if there is government notifications, Honorable Single Judge in the impugned order has taken note of it. At page 35 of the writ appeal, small Roman 2. And the learned AG, my lord, is online. He had shown this notification itself that this is empowering.
What that notification says, under which section of the act it has been issued?
My lord may see, it is under 28(3)P and the notification is dated 21/9/1999. In fact, the learned AG was
21/1/1999.
No, let me explain. As he concluded, Millard, let me explain the broad, the broad
on this.
Yes, I am answering that. I am answering that.
Succinct. He is not beating around the bush. He says he has.
This is a notification under subsection 2 of section 3. Millard, empowering the deputy registrar of the concerned division to exercise the powers of the registrar. Lord, that's not under 28(3)(p). Your Lordship may kindly turn to section 3 of the Act.
3. Section 3, subsection.
That is the definition of the registrar. Who can exercise that power? Lord, we are concerned with subsection 3 of section 3, which empowers the state government to appoint by any order or notification conferring the jurisdiction of the registrar within the local limits. So here the deputy registrar of Bhubaneswar has been conferred with the powers of the registrar by the 99 notification which has been referred to by the...
Where are you reading? Where are you reading?
Lord, subsection 3, the state government may.
Subsection 3 of...
subsection 3 of section 3.
Millard, section 3, subsection 3, Millard.
Chapter 2. 3, subsection 3.
Exactly.
Right. Section 3, Millard, of
page 48.
Page 46.
Appoint any society or local authority to assist the registrar, who shall exercise in the fifth manner such powers of the registrar
as may be specified in this said order. That order,
the powers of the registrar.
That's correct. So here, Millard, the deputy registrar is the authority who has passed the impugned order. Millard, let me just explain what is the case.
You must understand, Mr. Acharya.
Two aspects, let me clarify. Millard, two aspects. It's a legal question. Millard, they are contention primarily that the registrar does not have the jurisdiction to pass the impugned order, number one. Number two, they say that it is the tribunal which should have decided the issue in an election petition under section 67B. Both the answers, both the contentions are legally incorrect. Your Lordship is right when your Lordship pointed out that various authorities under a law can also decide the question of disqualification of a member. Let me just clarify. Here the member means the member of the committee, not the member of the society. If your Lordship would look at section 28, let me clear. He says that my membership from the society has gone. It is not correct. Member of the committee of management is different from the member of a society. Anybody can become a member subject to it. Doesn't to become a committee member. There are certain qualifications and disqualifications under the law, like RP Act. Now, and also, Millard, if your Lordship look at the scheme of RP Act, which is a tested law by now, there are various authorities to decide the question of disqualification of a member. An election tribunal, the High Court, it can decide the disqualification. The Election Commission of India under section 10A can also decide the question of disqualification. The governor under Article 192 can decide the question of disqualification. And the Speaker under Para 6 of the 10th schedule also can decide the question of disqualification. Doesn't mean that a single authority is empowered under law to decide the question of disqualification of a particular committee member. So here the case is, Millard, akin to that. Section 67B authorizes the state cooperative tribunal to decide an election dispute when it is brought before it. Section 68, Millard, which confers the plenary power upon the registrar of cooperative societies to decide anything pertaining to the management and affairs of management or etc. of a society, Millard, he is not bereft of any authority and jurisdiction. If your Lordship would look at the language employed in section 28(3)(AA), your Lordship may kindly turn to that. By operation of law, he ceases to be disqualified, ceases to be a member of the committee. Section, Millard, 28(3)AA, that's the apt provision. Your Lordship may kindly turn to page 91 of the book. This is very important, Millard, this is apt. Any individual, Millard, may I read, Millard? Section, subsection 3(AA), that is the answer to all his, Millard, contentions. Even if, Millard, there is no formal declaration, by operation of law, he ceases to hold office. No declaration is needed. Only, Millard, the finding, 3A, Millard, 3A. Any individual continuing as a member or a president of the committee whether by himself or as a representative of another society, incurring any of the disqualifications specified in subsection 3, which also includes P, small p, 28(3)P, or subsection 3-a, shall cease to hold his office, this is peremptory word, shall cease to hold his office as such with effect from the date he incurs such disqualification. It's automatic by operation of law. Even if a gap is there, your lordship can supplement it. Meaning has to be full, meaning has to be given effect to not. A disqualified, the legislative intent is not to allow a disqualified person to remain in the committee of management. If you are suffering from the vice of disqualification, you are out. Whether which authority will decide not the question of jurisdiction, it is very much there, ingrained in section 68 of the Act. So the deputy registrar, not only he did it unilaterally, he gave him ample opportunity of hearing to adduce evidence after complying with the principles of natural justice, giving him opportunity of hearing everything which has been recorded in the Honorable Single Judge's order. Milord, it's a full-dressed proceeding, Milord. Your Lordship may kindly turn to the finding. Lordship may kindly turn to the finding at page.
By operation of law,
yes,
if it happens,
yes,
do not say that
yes,
law is operated like this.
Right.
Suppose under the land reforms.
Who will decide? It's Milord section 67B. Section 67B, Milord, is an election dispute. Somebody may challenge, may not challenge, even if it is challenged, some finding of the tribunal does not, Milord, operate as a res judicata against another proceeding. If suppose from the finding of fact it is established that the person suffers from the vice of any disqualification on the basis of the contemporaneous documents available before the authority, and on due examination of all those documents, he arrives at a conclusive conclusion that no, you suffer from this disqualification. Milord, he is portraying the third child as the child of his brother because the name of the wife is similar. He says that Sasmita Mahanti is a common wife. My wife's name is Sasmita and my brother's wife's name is Sasmita.
Common wife. That cannot be a common wife.
Very bad. And one client will
not be a common wife.
Understand? I don't know.
I take an exception to my
So you say Sasmita is the wife of both. Sasmita is the wife of both. That is what has been discarded.
That person examination, evidence,
police case. All of it and has charge sheeted him for fraudulently obtaining this document number 1. Aadhaar card entry says he is the child of this particular Biswaranjan Mahanti.
They are all facts.
Birth record says this is this. Nothing has been so far. The tribunal is concerned he withdrew. Filed a petition, he withdrew. That doesn't mean that.
I'll take to the facts, I'll submit. But then
where is the
fact is this? Where is it already been recorded in the single judge order? Finding of fact has been arrived at. In a writ appeal, Milord, it can be disturbed. The very same, all those questions were raised. Your Lordship, can you look at how he has played the register of birth and date, Bhubaneswar, certified that Biswaranjan Mahanti is the natural born father of Bhuvanananda Vibhudananda Mahanti. He says this Vibhudananda third child.
I request Advocate General.
Wife's name is also my wife's name. So therefore he is not my child.
Mr. Ratho wants to say
Biological. Yeah, permitted.
It is not finding of the single judge.
My lord, say, in view of the findings given by the Honorable Single Judge, it is now that the registrar has no power. Honorable Single Judge has said that registrar, even if has no power, now I take over the jurisdiction of the tribunal. That for them, to that extent, they are not challenging.
Complete justice, the High Court
position is not final. Registrar has no power. Now, whether
the High Court can set its side to a patent illegally like this.
So now the question is, correct. Once you take over the tribunal, then I have to be given chance to examine. Lord, kindly see rule 57. Kindly see rule 57 of cooperative elections rules, Lord.
Entry number
Please allow
3
3 minutes go by. 1 second, Mr. Mishra, please. Hold power. Hold patience, please. Kindly see rule 57.
Let the entire
Lord, kindly see whether this complaint.
didn't say affects cooperative housing.
Kindly allow me to submit. Lord, kindly see rule 57 of Odisha Cooperative Society election rules.
Allegations.
Subject to the provisions of section 28B, disputes regarding any matter relating to election of the president or members of the committee of a society may be raised before any authority competent in that regard under the Act, and in that case, provisions of the rules under Chapter 7 of Odisha Cooperative Society Rules 65 shall mutatis mutandis apply in respect of such disputes.
One of the most.
Kindly see Chapter 7 of Cooperative Society Rules. Kindly see, my lord. Chapter 7 of Odisha Cooperative Society Rules.
One authority, not the.
Kindly.
Single authority.
Hey, we don't join issues. Kindly see Chapter 7. There is a clear limitation provided for. Now you are making a representation, if this person making a representation almost 1.5 years or 2 years after Chapter 7.
No, where is the election dispute? Malams, when kindly come to page 42, just one paragraph. No, I'm just assisting, man.
We are all appearing.
We are appearing. Paragraph 19, your lordships will read. No, it clarifies. I'm just placing this. We have to understand. Yes. With the power of the tribunal relates to an election dispute.
Right.
Yes. Where is the election dispute? This writ application was treated as an election dispute, and the honorable single judge. That's what the order is.
Incorrect. Please.
This is what he has
This was
written.
never treated as.
The order, yes.
The order reflects this.
Kindly see the order we challenge, my lord. Page
119. Your lordship may kindly go through paragraph 9.
Dispute is different.
See your disqualification order.
Your lordship may kindly see paragraph 19.
Kindly see.
He treats it as an election dispute.
Yes.
Says that
Because the tribunal was not functioning at the relevant
the powers of the election tribunal and deciding.
And that is final so far as they are concerned.
And that is final, so no one appeals against it. No, that's all right. Where is the election dispute? For the tribunal to exercise.
Yes.
For the tribunal to exercise.
Lord, yes.
The sine qua non is the availability of a dispute, and that dispute should be election dispute.
Right.
You have taken us
Right,
through
my
that
lord.
section.
Right, my lord. Kindly see the order we challenge before the honorable single.
That order is
Page 120.
20.
Yes.
120.
Kindly see this order, this laconic order, your lordship, just see this. This Annexure 8 of the writ petition, page 120. Kindly see whether this is the basis on which a disqualifying an elected person can be passed at all. Kindly see this note, page 120. This order is passed by Deputy Registered Cooperative Societies.
120.
Yes, my lord.
Annexure date of the order.
The order is 19th of 11, 2024.
That is Annexure A, page 52.
Page 15.
In one of the petitions.
Yes. Kindly see.
Let us read slowly.
Yes.
Keeping emotions aside, intimation with regard to disqualification from membership of Committee of Management and President of Capital Cooperative Housing.
Yes.
Letter number registered.
I am to intimate you. As per final report and charge sheet of investigating officer in Lakshmisagar PS case number so and so, and joint inquiry report of the joint register, the Bhubaneswar Joint Directorate of Bhubaneswar, wherein it is established that you have more than 2 children, hence you incur statutory disqualification 28(3)(b) of the OCS Act. Copy of the final report, charge sheet, and the joint inquiry report enclosed herewith. You are therefore not eligible to continue as the member of the committee. President so and so with immediately. Kindly see the laconic order. Kindly see the tenor of the order. I can say it as a draconian piece.
Let us see.
Your lordship was repeatedly asking what question to be answered. Where is the election dispute? Annexure 11 is the election dispute. That has been withdrawn.
Now it is an election dispute. Not my first submission is in connection with disqualification on section 28B in the framework of entire Cooperative Society Act or anywhere in the rules, this inquiry is not contemplated.
No, you are not answering the question.
Yes. So I
agree. Tribunal exercises power in respect of election dispute. In 1951 or 52, the Apex Court defined what is an election dispute.
Correct.
That is
NP Punuswar
versus returning officer
Namakkal.
It has defined.
I have given.
What is an election?
Yes.
There is such a dispute here.
Here, this disqualification
Itself
pertains
is a
to.
dispute.
Yes.
Yes.
Disqualification itself pertains to election of the candidate.
Sir, kindly look to explanation 3.
Explanation 3. To which section?
67B. Explanation 3.
Go to that 67.
Yes.
I have that book. Wait.
Power of the tribunal. Question whether a person is or by the member of the society or not shall be a dispute within the meaning of this section.
Whether a person is.
That would be 68, not 67B. You are reading a wrong provision.
67B, which was incorporated to the IDC.
67B.
Tribunal, yes, B, capital B. Notwithstanding anything contained in any law.
Where are you reading?
67B.
Number 1A. 67B, 1 Roman 1.
Sir, no. That is explanation of the see that explanation 3 of that 67B, explanation 3, Roman.
There is no explanation at all to this section.
Now, Roman 3 is there. I'll place it. Roman 3, all disputes. This is the answer to your lordship's query.
1 second. All disputes.
All disputes arising in connection with the election of.
Where is the election dispute?
This is the issue. Disqualification ipso facto, it's an election dispute.
No, I'll answer. Millard, I'll answer.
No.
Election. Millard, your lordship may kindly. Your lordship may kindly.
Scrutiny of the nomination.
It is there.
Voting of
Absolutely
the declaration of the result. Election dispute.
My lords, election dispute starts from the date of notification, scrutiny of notifications, objections filed at the time of scrutiny.
Correct.
All those come within the ambit of election dispute.
Correct.
No, I am explaining Mohinder Singh Gill has answered Millard. From the date of issuance of notification with the declaration of the result. Not beyond it.
There is a cloud outside, I understand. But there need not be so much charged atmosphere in the court. All should smile. It's a life game.
Yes.
Smile and proceed. Now my question is, assume for a moment, Mr. Ratho,
Right, my lord.
to contradict your version, proposition.
Yes.
I am giving you an example.
Right, my lord.
From logic now. From logic, we will go to the logic now.
No, logic is not required. Statute provides.
1 second. A moment. To defeat your proposition, I am giving this logic. Suppose after 5 years, 3 years,
Right.
4 years,
Right.
he begets a child.
Absent. Very uncertain.
On that ground, if he is disqualified, do you mean to say it's an election dispute?
Absolutely, Millard.
After 4 years of the election. After 4 years of election.
Yes.
Yes, he is disqualified.
Disqualified. Does it become election dispute?
That itself is a dispute.
Dispute?
Yes, that itself is a dispute. Lord, I humbly.
It is a dispute, we don't dispute. Dispute is
And that is an election dispute. That is an election dispute. If your lordship remembers, the disqualification provisions in the constitution, in the Gram Panchayat, that collateral, other parameter provisions, is or has become disqualified. In the Gram Panchayat, Panchayat Samiti Act, and in the constitution also, if your lordship sees, in the so far as MPs, MLAs, commissioner.
Small thing. We want to learn from.
No, whatever I have within me, I can explain it to your lordship.
Kindly explain.
For the purpose of disqualification, deciding disqualification.
Kindly.
Yeah, and constitution. Both.
We are that fast in learning. Otherwise, by your fast grown as Aristotle, we have not grown. We are asking you an example. Election takes place in February 2022.
Right.
The tenure is 10 years.
But I'm straight to answering that only.
I have not put the question at all.
No, your lordship has already placed me the question just before. Just before.
We'll explain to you. Now, in after 2022, 10 years means 2032 February. In January 2022,
yes,
he begets a child.
Yes.
On that ground, he incurs disqualifications. Does it become election dispute? Is our question.
Sir, I am answering that. For that purpose, that is a disqualification.
Article 190.
Because of determination of that disqualification, there is no procedure there in the Odisha Cooperative Society Act, nor any authority designated for that to decide that issue of disqualification.
Not even tribunal.
Yes.
Other than this.
That means that he says not even the tribunal.
In past, I'm saying there is no procedure how to determine the disqualification. There is no rules how to decide that the issue of disqualification. That is why I am saying this issue of disqualification, since pertains to election of a candidate, it is only and only an election dispute. If a lordship gets any provision anywhere in the Cooperative Society Act or election rules or in the rules designating an authority to decide the issue of disqualification, unlike in the Panchayat Samiti Act, Gram Panchayat, the collectors have been authorized to decide the issue of disqualification. The constitutional provision mandates that. And also in the Assembly, MLA and MP, Commissioner of Election is they have been empowered with the power to decide the question of disqualification. And there is a full-fledged trial provided for even before that authority. Leading evidence, producing documents, giving opportunity to rebut those documents. Here your lordship may see the manner it has been dealt with. Police submitting some charge sheet, then you are holding an inquiry is not contemplated and disqualifying me. I am an elected representative, my lord.
No.
Let's make kindly also say.
Let me answer.
88, 60.
Your two submissions you are making now. Number one, the authority who issued that order is incompetent. Incidentally, you take us to the provisions under which tribunal is established, and the next provision which vests power in the tribunal. According to you, this partakes the character of an election dispute or not. Such a dispute, if it arises, it has to be decided by the tribunal, not by the authority who decided.
Or by a designated authority.
Or by
a designated authority in the framework of the law.
Who is the designated?
There is no designated.
Therefore, according to you,
so it has to go to the tribunal.
Tribunal. In other words, tribunal is exercising all pervasive jurisdiction.
That's what I'm
Wherever
saying.
authority is not
That is what I'm saying. Just my lord, you
look to subsection 3. But possibly I was not.
Subsection 3 of which section?
Subsection 3. Subject to object. Accept and putting a question that whether the tribunal has the power, except the election, any matter in connection with election, whether the tribunal can exercise power. I'm reading. The tribunal may.
Can I request you, sir? Right. Mr. Come to Roman 3 of 67B. Let us read whole provision. Every provision we see that now.
All disputes arising in connection with the election or of any office bearers of a society or the disciplinary action taken by society or its committee against any paid subject of the society, with whatever authority under this act, rules or any regulation framed under this act, pending as on the date of commencement of the Orissa Cooperative Society Amendment Act 1991, shall transferred to the tribunal, which shall dispose of the same in accordance with law. That is one aspect of the 67B, subclause 3. Then you have 67B, subsection 3. Subsection 3. The tribunal may call for and examine records of the proceeding in which appeal lies to it, but appeal has not been filed, for the purpose of satisfying itself as to the legality or propriety of past or decision made therein. And if in such case it appears to the tribunal that any order or decision should be revised, modified, or annulled, it may make such order as it thinks fit, after affording the person likely to be affected adversely by such order an opportunity of harm.
Where the appeal lies to the tribunal?
So far the appeal is concerned.
109.
109. No, this is not an appeal.
109 is under. And interestingly, your lordship will find no opportunity of hearing is also given.
Absolutely not.
You are disqualifying me, hanging me from this elected body. No opportunity of hearing not given.
Yes, it is given.
Where I could have taken all these ground, I could have produced documents, I could have rebutted the materials against me.
And the suspension of the committee has been disposed of in one line order.
Disqualification.
Let's look to that order. Of course, Mr. Kanungo is appearing in that case. He can also address your on that.
No, man. Learned senior is addressing about it. This was.
Representation का कहीं? Representation का कहीं?
One more clarification. You mean to say election dispute is one species. There are other disputes which also should be decided by the tribunal.
I could not get your lordship, Lord. I could not get your lordship. I'm so sorry, my lord.
So far as election disputes are concerned,
Yes.
the tribunal has jurisdiction, nobody will dispute about that. Is it your case that whether this is election dispute or not, dispute of the kind should be raised only before the tribunal?
My lord, that I think within the framework of section 67B, whatever is designated, whatever is empowered to the tribunal, because it's a statutory tribunal. It can't go travel beyond scope of section 67. Lord, if your lordship, I'll just request today, lordship, kindly see that representation against me, which was submitted against me by a person who is no way connected to the cooperative society. Kindly see that. Lord, kindly turn to page 100, running page 22. Annexure A by 3 of the counter. Here is a person.
Page 18 of council.
May I explain a few things subject to your
Yes.
answer?
Yes.
Could I, Milord?
Yes, yes.
Because otherwise, if my learned friends wants to continue, Milord, it can be taken up some other day. I'll answer. No issue.
They have argued now.
No.
We have understood.
Let me start.
Material
Your lordship I'm so grateful. I'm so grateful. Your lordship have raised two pertinent questions which they have not yet been able to answer. Number one.
Question. Other two questions you have to answer it.
But I'll have to answer subject to.
How it question arose, how it is treated, how judge partook the character
I'll have to
of a
answer it.
tribunal.
I'll have to address
These
your
things you have to
lordship.
answer.
I'll have to address your lordship.
Let me tell the legal position. They will explain. Factually, I am not. Yes.
Mr. Acharya, we have one submission to you.
Yes.
Let this side address. Thereafter,
So
you can tell by way of.
with all humility,
That's
Lord.
correct. I don't have any. So, may I pray in that event?
It's not the date tomorrow again. Tomorrow.
Tomorrow more wrong. I'm not here until 26th. There are some Supreme Court matters.
I appreciate
To what period
Next
you will?
week, Milord, next week.
Next week, any day, so that we can address.
so that we'll also systematically address your
After 2 p.m., your lordship may fix up without disturbing the normal schedule. Your lordship may fix up at 3 p.m.
Online.
No,
I will come physically. Don't worry. I was here today. I was thinking it will come before.
He will physically present, but he will be also ready to argue online.
Online. Otherwise, week after next.
Yes.
Week after next.
We'll have
Next week, Milord, on 2nd of April. On 2nd of April.
Yes, sir.
Mr. Acharya, we are
15th April. 15th.
15th of April.
15th of April.
Ah.
Deeply obliged.
15th on this or the other matter was deferred. That's nice to complete this matter.
My lords may not take me otherwise if I have said.
No, you are an effective counsel. Otherwise, how you are paid to argue.
I take it in a lighter way to learn Advocate General submission. Common
I
wise.
am too spirited. Don't worry. We are all actors on the stage. Why are you worried? So it is up to my lord to decide. We have to and I'm not a cantankerous lawyer that I will be stinking.
He's reminding us
of April after 2 p.m. after lunch.
buttons.
Polyandry. Polygamy, polyandry.
Right, my lord.
But I fail to understand how there can be one wife of 2 persons. Still, I'm not getting the answer.
In Himachal Pradesh, if you go,
But there cannot be a common wife.
We are hard about Pandavas. But I'll come and answer, don't worry. I'll come with documents.
in Uttara,
Documents.
I'm
He's already
told
out. What interim order?
such a
He's already out.
because of poverty.
Yes.
They follow.
Milord, he's already out. There is no interim order.
No, there is interim.
No, that is with pertaining to election, fresh election.
That is continuing. That is
Whatever
continuing.
entry part is there, we have to continue.
That's correct.
City model to class. Third part. Call on in April for further hearing. Until then, that whatever interim order obtained this day, come on.
No, your lordship may clarify. That is pertaining to the election notice.
Whatever interim order.
That is cooperative election.
Order was of status quo.
We are not asking for any further interim order, whatever is there.
Yes.
So grateful.
We are grateful to you.
My lord, item 12.
Item 12.
I'm sorry.
Item 12, my lord directed the officer to file an affidavit with regard to the promotion of OS and chief OS in railway that after pronouncement of judgment before the tribunal. My lord, in the last date directed that unless such the last order may be seen, my lord, that is a retrial portion.
May I submit, my lord? My lord.
Yes, Mr. Paddy.
Yes, the concerned officials who is dealing with the matter, he was present me about 11:30. He has very chest pain. Take 2 Servitran. Doctor wants he is shifted to hospital. So can we, any other officer will be joined with us and he will be on next week any day?
We will call this matter on 16th April.
Yes, ma'am.
All the 8
Officer who is joined, Narasimha reflect also any other officer as well can join and
8th of April.
8th of April, my lord, that is the way see the condition, my lord, that
But
he
you bring him. Not necessary. Your lawyer is very competent. Even without you, he will argue more.
No, so long you will bring him, the government.
My lord directed that he should from the form 6 is the question.
Getting hearted.
Form 6 that is not good. My lord.
All right, on 8th April. 8th. Yes.
Item 16, Writ Appeal 1868 of 2024.
Last writ appeal, and some other. First writ appeal, no, all writ appeals at a time we are taking. Serial number?
Not
16.
Item 16.
All common matters, no?
These are not the common matter. Not the common matter. The second item is there is an advertisement of 2020-21.
It's not of the common order. The second judgment, writ appeal is not arising from the order that other both writ appeals are arising.
It's a different matter.
Different matter.
Not of the similar order.
D-tag, yes.
Okay.
D-tag the writ appeal number.
Which matter?
2985.
Which one? 2985.
My lord.
2985 of 2023.
And 2542? 2542?
2542, my lord, that's both of them are arising of the same order. But this is arising.
Only 2985 to be dictated.
My lord.
Two 2985 to be detected.
Yes, my lord.
All right, detect 2985 and submitted at the bottom. Call up previous. Other two matters? Ready?
I pay your thing, kindly taken some other day.
All these matters?
Only I mean 1868 from 2024.
This one? This one.
No, 2985, I'm reading, bro.
1868. Item 16. That is will take 3 weeks. Let the request is to be along with another. OPS, which OPS is very
See, two tag को जो deed tag करे
Yes, that's the deed tag and rest other two matters will remain as they are. Okay? Yes. Call after 3 weeks. Yes. At the request. Great.
Well, it's in that matter, the ancillary issue involved in the first matter will affect them. The ratio of the...
We'll call that matter that day itself.
Yes, ma'am.
But we'll not tag it.
Great.
See, call that. Call the...
I'm not, despite not the order, I'm not getting the appointment. Short date will be given. Next
What
week.
date?
Yes.
All right.
The second matter, 2985.
All 6-4. All 6-4. All matters? All matters 6-4.
Item 17 and 18 have been adjourned. Item 19.
Interim order to continue.
Item 19.
One matter there is interim order,
2985.
18 also adjourned.
My lord, item 19 is the appeal by the state.
Yeah.
Where, my lord, involving delay of 231 days. My lord, the direct operative portion of the impugned order, Lord, you may kindly have a glance.
Go to 1919. Personally regularize the service of petitioner retrospectively.
Retrospective.
With effect from 1992. He has retired now, perhaps, sir.
He was regularized in 2016.
Yes.
And extend the pecuniary benefits.
Only that period, 1992 to 16.
February 92 to February 2016. Now, what is the lacuna in the order?
Only one resolution, Annexure 2 at page 79. Page 79, Lord Mercy. 49/2012 resolution by the government, which was neither challenged nor interfered nor quashed by the Honorable Single Judge. It is still subsisting.
What does it say?
The scheme of regularization.
That is only executive scheme, not statutory.
That is the scheme of regularization, my lord.
Only if it is a statutory order, challenge has to be laid.
No challenge was made.
No, because it's not a statutory order.
What is the force?
That contents were not taken and not discussed in the order, madam. It is still.
Kindly be seated.
Madam.
This High Court appeal by the state seeks to call in question a learned single judge's judgment dated 22/7/2024, whereby respondent employees WPC number 37540 of 2023 having been favored, relief has been accorded to him as under. There are 11.1, 11 and 11.11. Complete 11 and 11.1. This appeal has been preferred after brooking a delay of how many days?
231 days.
231 days. First off, an application in I number so and so supported by an affidavit is filed seeking its condonation. I number 1897 of 2025 supported by an affidavit is filed seeking its condonation. First one. Learned counsel, learned AGA appearing for the appellant vehemently submits that the impugned order has a legal infirmity in as much as learned single judge failed to see that there was no challenge to the government resolution dated
4/9/2012.
4/9/2012, a copy whereof avails its annexure to 7. He adds that had the content and intent of this resolution was kept in view, comma, relief of the kind could not have been granted to the respondent employee. First one. Thus, a gross error having occurred at the hands of the learned single judge, comma, interference of this court is eminently warranted for setting the same norm and thereby doing the justice to the appellant. Next paragraph. Having heard learned counsel for the appellant and having perused the appeal papers, we decline indulgence in the matter. Firstly, because for the following reasons. Number one, the appeal has been preferred with a long delay of 231 days. Yes. An application is filed supported by an affidavit seeking condemnation or delay. A perusal of the application in the light of the affidavit would show that what has been stated in them is more like parrot speech. First of all, the parrot version in the pleadings would give an impression that things have been done without due application of mind and in a ritualistic way. First of all, the application does not give a plausible explanation for the delay, long delay proved. First of all, such applications cannot be positively entertained with leniency merely because applicant happens to be the state or its functionary. First of all, in more or less similar circumstances, we have rejected applications of the kind, and therefore we have to take the beaten track here also. First of all, accordingly, application is negative. First of all, as a consequence, appeal also would have logically been negative. First of all, however, we are undertaking examination of the appeal on its merits. Next one. Go to the order. Okay, go to order. Appellant respondent employee was before this court in WPC number 14961 of 2023, wherein a learned single judge, by order dated 17/5/2023, had directed the jurisdictional authority to consider case of the respondent for regularization of his service notionally with effect from 20 February 1982 to 14/2/2016 without monetary benefit, and to extend monetary benefit from 15/2/2016 onwards, that is, the date of joining of the respondent in the post of peon on regular basis, in terms of the ratio in Amarkant Rai case, the citation. However, without whispering anything about the required ratio, the jurisdictional authority had passed an order superseding the entry as to previous order number 32676 dated 12/9/2023. Such a course is offensive to judicial process, to say the least. Next part. The vehement submission of learned counsel, learned EG appearing for the appellant, that the Finance Department resolution dated 4/9/2012 has got a bearing on the matter, has been very specifically dealt with by the learned single judge in paragraph 6, which reads as under 6 and 6.1. Paragraph 7. Description. It goes according to the order of the operating. Several then. we have to issue. Mr. We don't agree with this order.
Well,
We'll issue notice is not ordered.
notice is, sir. It is after notice.
This is after notice matter.
Yes, my lord.
After notice matter. What is this order?
On limitation, along with limitation notice.
We'll condone delay now.
25/7/2020.
It is impossible to know what the learned single judge is saying, except saying last word. Where is the reasoning?
So
We
many.
are very sorry with due respect to the single judge. This is not the kind of the order we sustain that.
But so far as Jago and Shripad is concerned, I can take benefit now.
Where is the treatment of the subject?
That is not.
It is more like a jurisprudence which is dead and gone.
But
No, we don't agree with this.
the first order which was set aside by single bench and remanded back.
After booking a delay of so and so, an application supported by an affidavit is moved, seeking its condonation. So first up. Delay condone with which order?
Yes, that is
No, we have not done. Earlier it is
Is there any
21/11/2025.
We'll hear this matter at least.
21/11/2025.
No, that's all right, Mr. He's not on that ground, but on some other ground which you are noticed. We'll hear this matter some other day. I don't call this matter after 4 weeks. I think of how to sustain this order.
But there are grounds in favor of the opposite party for a direction to be regularized.
Let us
Other judgments are there.
anyway now
And he was appointed against a sanctioned post.
let us see. There some time we'll afterwards we'll hear, because after reading this we do not find that way. With due respect to the judge, let us see. Call after 4 weeks.
The lordship fixed it.
After 4 weeks.
4 weeks. There's already retired person.
All right.
6th of April.
6th of April is difficult. 8th of April.
8th of April. Probably.
Item 20, Read Appeal 740/2025.
May I please, Your Honor, in this case, the petitioner has challenged the order of the Honorable Single Judge. Cancelling the candidature of the petitioner just before 14 hours before the election. Election was to be held on 29/3/2025. The petitioner filed her nomination and was busy.
Election notification is dated.
Yes,
Is dated?
1/3. 2025. That in the read is page 23, I have given that.
1/3/2025.
Yes, ma'am.
Election notification.
Yes, ma'am. Then
issued by whom?
Election officer. He has been made as a, in this writ appeal also I have made them a party. In the writ application, he was made as a opposite party number 3. Election officer. 1 and
who is the respondent number?
respondent number 3 is the election officer. May I take your lordships to the page 23, running page to page 23.
When did you file the election nomination?
Nomination, that is 7/3/2025. It was filed on.
1 second. Kindly, only answer your question. These are all paternalistic matters. You cannot go on arguing the matter.
Problem.
7/3/25 nomination was filed by you.
Yes.
Scrutiny took place when?
Scrutiny. 9th was the date.
9/3.
Yes. And my name also found place, that is, that also I have filed.
How many people were in the fray?
That is for the post of executive member. So that they are Cuttack Bar Association.
11 members were there.
11 members. Out of 11,
Whether have you made all the 11 members as the respondents in this case?
no.
Then on that ground, your petition goes because of this code.
Oh, may I know your lordship's my lord? Which petition? Writ petition was filed by the President Cuttack Bar Association, who is having no right to file it as per the CBI rules and regulations. May I take your lordship's?
Petitioner is the
Petitioner is the Cuttack Bar Association as alleged,
Cuttack Bar.
represented by the President, which is not, which is illegal. Because CBI rule and regulation speaks up that only President, Secretary.
You want to argue or you want to quarrel with us?
No, not
argue properly.
because it is not.
No, that is why.
If you do like this, we'll say before other bench. We'll send you before other bench. Be slow, be gentle. You are a lady. We assume that you are a gentle lady. Kindly be gentle to us.
Yes. Now, when the case will
raise your voice, we don't like that. We can also raise our voice.
We are going to the review, read appeal, so many things. He has been harassed so that I am, to some extent, 1 year has passed.
Who harassed you? Did we harass you? No. Therefore, don't harass.
To some extent, courts also. Because of wrong order passed, the review we went.
That happens.
Yes.
God harasses.
Yes, I have no objection to that. But my matter may be properly heard.
Petitioner is the Cuttack Bar Association.
The same thing.
Yes, my lord.
Yes.
That is page 43, it starts. And
1 second.
annexure 9.
1 second.
I have
When
annexed the whole writ application, I have annexed.
When the elections were held?
29-3. Date chart, your lordship may see.
29-3-25 elections were held.
Yes.
Who were elected?
List
Who were
of-
elected?
This was filed by the President Cuttack Bar Association
We are asking.
before the election, so that question of winning candidate does not arise here in this
Subsequently,
writ
election did
application.
not take place.
Well, 29th it took place.
Therefore, we want to know who were elected at least.
Some
You can say, I do not know, because
Yes,
the
some
petition
persons.
does not reflect. All right. Then president of association went to the writ court.
Yes.
It's true. Not true.
May I take your lordship, my lord? If let me place my matter, then only your lordship may. Yeah.
Hello, we can ascertain without your permission. We can ascertain from anybody, anywhere who is sitting here. How can you prevent us from doing it? Because we have to do on
Wrong affidavits are being filed. I shall bring to your lordship's notice.
We are telling you, we have power.
Wrong.
We have power to
Yes.
ask anybody in the court hall any question we
No,
want
no grievance.
relevant to this.
But only thing that my matter may be
When we-
properly heard.
We are doing that job. The only thing is you have
Telling
to
us not-
ask the question. If you go on, we are doing like this, we will go on asking questions to everybody.
From the beginning.
By that time, next election comes. That will not help you.
Yes. That comes now.
All right. According to you, who had challenged the election?
According
Election has not been
Not been
challenged.
challenged.
May I take your lordships to page prayer of the writ application?
Annexure 9
Yes, my lord.
of the writ petition.
Yes.
Writ
Whole writ application I have annexed so that in the writ appeal also, prayer portion that is in page 59.
Yeah.
Has your lordships got it? 59. Running page. Has your lordship got it? May I read it?
Yes.
The petitioner therefore prays that this honorable court may graciously be pleased to admit this writ petition, call for the records, and after hearing the parties, allow the same with cost and issue a writ in the nature of certiorari mandamus or any other or further writ direction be pleased to direct the opposite party number 1, 2, 3. 1, 2, 3 means State Bar Council and the election officer to delete the name of Miss Chameli Raut bearing enrollment so and so at serial number 393 of final voter list for ensuing election 2025-26. Annexure 1.
Your client.
Yes. They prayed for relief against opposite party number 1, 2, 3 to delete the name of the present appellant, one of the valid member. Then thereafter what has happened? That election counter filed by 18.3 some order has been passed in writ application. May I take your lordship to the docket that 18.3 the case was filed. No notice was issued. Thereafter, only 18.3 notices were issued by special messenger. During the election process was going on, these notices were sent. (18.3/2025) order was passed in the interlocutory petition. As an interim, it is directed that pendency of the writ petition will not be a bar for opposite party number 3. 3 is the election officer to take a lawful decision on annexure 13. That is 18.3.
Where your name was sought to be deleted.
Yes, madam, from the valid voter list. And accordingly, I filed my nomination. Money has been received. I have filed those challans also. And when I was busy in putting flags and all ready to participate in the election, this 18.3, this order was passed. It was behind my back because no notice were sent. On 25th only I came to picture because 21.3 by special messenger notices were sent. And there is also wrong recording that I refuse to accept because my client's mother, 86 years, suffering from brain stroke. That medical papers also I have sent. I was not there. From the docket today only I perused. He has written that door was locked. She was absent. But when after taking phone number from the neighbor, he talked to the present appellant. She stated that I am at Kotak CDA to look after my mother. Then thereafter, she inquired about the matter and 25th when the matter was listed, she was present in the court. Then on 26th also, the matter was taken up. She was present. In my writ appeal, I have mentioned she was humiliated, she was misbehaved, so many things. And she has asked for 26th, she was very much present. Senior counsel Vibhuti Mishra also is present, who is appearing for that election officer. Then I have asked for the virtual hearing. Dated when the matter was listed on 139, she was very much present. That was not given. That it was not recorded. That is the statement given by the registrar of the High Court. And thereafter, what has happened? On 27th, as my mother was suffering from brain stroke, I attended her so that she could not come to the court. But she doesn't know because 26th she was present, 27th matter was listed, 27th she could not be present because to attend her only.
No, that's all right. What is the electoral disorder?
Yes, madam. Now,
what the single judge disorder says, let us read the operative.
Yes,
question.
madam. Non-speaking order, that is.
The operative.
That is, yes, madam. I am reading now. But page 23, madam. May I take your lordship to page 23? It starts from, yes,
Read
ma'am.
appeal.
Your paper book.
Yes, ma'am. Writ appeal. Running page 23. This matter is taken up through
No, we are not on the same page.
Order dated?
28-3.
interim application order has been passed. In the interim, opposite party number 4 shall not
It is
be
open to him to take decision in the matter on that representation. That order.
court shall not be allowed to participate in the process of election in respect of Kotak Bar Association to be held on 29th March. That is Annexure 7 to the writ appeal.
Who is party number here?
Appellant.
Opposite party number 4. She was the opposite party number 4 in the writ application.
You are a client, appellant here.
Yes.
Order to pass in the process of election for association. So why this order?
May I take?
We'll have a small response then from them. Then we'll hear you. Okay. Yes. Why this order, brother? And how writ petition was maintainable?
Because the draft voter list was is to be issued by the State Bar Council. The membership of appellant was cancelled by the Bar Association. My lords, may kindly take a small date chart I have prepared.
Now, against our general impression of election law is where the nomination paper is to be rejected or not. It's a matter left to the scrutiny office, election officer.
Yes.
Election officer will do that. Correct. If there is any grievance, it should go to election tribunal or maybe civil court also. We don't know.
Yes.
Is there any election tribunal?
Yes, ma'am.
Election tribunal is also there.
There. Why during the
Here,
process
my lord,
of election?
Here, my lord, here under the rules, my lord, State Bar Council rules, framed by the All India Bar Council, after final publication of the voter list, if any mistake is found in the electoral roll, as per Rule 81, the election officer is to delete the name or to add that name. My lord, may kindly, I will point that. My lord, may kindly see Rule 81 of the rules framed by the State Bar Council.
State Bar Council.
That has been because
Model rule is from
All India Bar
All
Council.
India Bar. Do you have
Sorry,
copy of it?
my lord, may kindly see Rule 81.
We'll look into it.
Yes, ma'am.
If you don't have copy, you will get the xerox of this. Get xerox of this. Use it.
Book I had sent, book was not available.
What does it say in your language?
Suppose, my lord, the first Bar Council, State Bar Council is to send a draft voter list. Suppose any name has been included wrongly, then we have to intimate to the Bar Council for deletion of that.
The electoral roll.
Yes, draft voter list.
Voters list.
Yes.
Is prepared by whom?
Prepared by the State Bar Council.
State Bar Council.
Yes, ma'am.
This is Bar Council India.
No, State Bar Council.
No, election is
election to the Bar Association of the
Bar Association or Bar Council?
Bar Association.
Bar
election.
Association.
Yes.
If it is Bar Association,
yes,
how writ petition was maintainable?
Under the
I don't get this.
Not under the rules. Actually, these membership was cancelled by the general body of Bar Association.
Correct.
So after the draft voter list, Bar Association wrote to the State Bar Council, you delete this name because her membership has been cancelled from the final voter list.
If, final voter list of bar council it is.
No, bar, draft voter list and final voter list is to prepared by the State Bar Council.
For which election?
For the Bar Association elections also.
Bar Association or Bar Council?
Bar Association election also.
Which rule says?
That a new rule has come, my lord.
Take you that.
Lord, in the Bar Association election now
it is essentially election relating to Bar Association.
Suppose, my lord, High Court Bar
We want to.
Yes, my lord.
Is it a case relating to Bar Association election?
Yes, my lord.
Office bearers,
Yes.
etc.
Yes.
President, treasurer.
Like our siege on 28th.
That.
Like, correct.
Who prepares the voters list?
My lord, State Bar Council is to first give the draft voter list.
Bar Association election?
Yes, my lord.
Throughout the state.
Sabu Bar Association, all Bar Association, yes.
Individually.
They have to segregate from the State Bar Council list, they have to segregate a Bar Association wise list. Because each member has to give, suppose I am member of 3 bar associations, I can only vote in 1 association. So they will take an option from us and accordingly they will prepare a separate bar association list.
So that he will not duplicate his vote in other elections.
Yes. So draft voter list is sent by the State Bar Council to the bar association for verification. Any name has been included, is to be included or to be deleted. Cuttack Bar Association wrote to the State Bar Council that this person's name has membership has been cancelled, so delete the name. But in the final list, the State Bar Council, without deleting that name, sent it to, again that name to the Bar Association. Election officer has power under Rule 81. I just place Rule 81. First, what my lords asked, publication of the electoral roll. The electoral roll finally published by the Chief Electoral Officer, Secretary of the State Bar Council, shall be issued dispatched to the President, Public Secretary to the concerned affiliated bar association of the respective affiliated bar association 45 days before the date of election with instruction to notify the same in the notice board of the bar association and convene a meeting of general body of association to appoint one of its voters as election officer as defined in Rule 2 and intimate his her name, address, serial number in the electoral roll and mobile number to the Secretary Odisha State Bar Council so as to reach before 35 days immediate preceding the date of election. So Bar Council is to, State Council is to prepare the list, my lord. Now, my lord, may kindly see 81. I'll just place note, the election officer shall notify the serial number, name, and enrollment numbers of the voters whose name appear in the electoral roll as the advocate not eligible to vote in the election as per list submitted by the executive body due to suspension, expulsion from the members of the concerned affiliated bar association or due to non-clearance of the membership dues or any other dues by notifying the date of election and the schedule of program. So, my lord, as the State Bar Council does not delete the name, so that representation under Annexure 13, what my friend was saying, that was given to the election officer to delete her name. That election officer also did not took any steps. So we came before this Honorable Court. This Honorable Court, my lord, issued notice.
Election officer is a statutory.
So election officer is to be appointed under the rules, my lord, by the general body of the association.
Then he does not exercise any public power at all.
No. Power 81, Rule 81 power has been given, my lord.
Rule 81 is a society rule.
No, State Bar Council rules. State Bar Council rules.
whether the candidate was expelled from the membership of.
Prior to that, I have given date check, my lord, may kindly see for a moment. Yes.
When was that candidate expelled?
My lord.
Deleted from the role of the electoral.
No, deleted, not deleted. She was, her membership was cancelled by the general body, my lord.
Membership.
General body.
Membership of the bar association was cancelled by the general body. That rule 81, my lord, may kindly see. Membership was cancelled by the general body.
'81 speaks of eligible voters, non-eligible voters.
Yes, my lord. With non-eligible, my lord, under the bar association rules, if any member is expelled or for non-payment or any other, there are a number of grounds. So her membership is to be cancelled.
Cancelled on what ground?
My lord, here, my lord, Article 8.
No, XYZ.
Non-payment.
Yes.
The candidate's appellant's candidature was cancelled.
Under Article 8
on what ground?
Article 8 subclass 2, my lord.
What is that?
Every member of the association shall maintain utmost decorum and discipline inside the premises of the association and shall not act in contravention of the objects, rules and regulations of the association.
What was the conduct, objectionable, culpable conduct of the appellant?
My lord, on 2/8/20, my lord, may kindly see I have given my date check. On 2/8/24, the present appellant, who is an advocate, assaulted and abused members of the Cuttack Bar Association. My date check I have given you. And on the same day, my lord, Lalbagh PS case number 146 of 24 filed by Miss Pinky Jaina, advocate, against present appellant. Present appellant also filed an FIR.
Against her?
Yes, my lord.
This is a FIR, counter FIR.
Counter FIR. Now, my lord,
any investigation has taken place?
Yes, no, charge sheet has been filed.
Charge sheet has been filed?
Yes.
Which is that, what you call it, a criminal case in your case? PCR, what is that you call? CC, what, when the police...
PS case number.
PS?
PS, police station case number.
Police station, PSC.
Lalbagh police station case number 146 of 24. I have given in my note, my lord. And the charge sheet I have filed, my lord.
What happened to the trial?
Trial has not commenced.
What had come in?
Cognizance has been taken. Today I have filed charge sheet along with my objection to the argument. The charge sheet I have annexed, my lord.
You served a copy of the objection on your friend?
Yes, my lord.
Charge sheet has been filed today.
No. Today I have filed along with objection, copy of charge sheet.
This is for punishable under sections what? You have not said which section, which offense.
My lord, may kindly see the last page of that charge sheet. Cognizance has been taken by the court under section 126(2), 296,
126(2). What is that?
126(2).
Now, what is that? Wrongful restraint. Earlier 221.
Then 296.
Obscene acting songs in public.
Obscene act in public places. Then 118(1).
115.
118. 118.
Now, madam, your client wants to vote in the election now. Election is scheduled to be held on which day?
On this 28 March.
28.
Yes, ma'am. Before passing that order, may I take your lordship?
No, we are asking.
Counter has been filed.
Madam,
by-
please wait. Listeners, what do you want?
We want to put a question to you so that we can know more about your case.
That day, your lordship also raised that question to me that she will be allowed to vote and it will be in a paper sealed cover or that way. That I think, my lord, this is a case. All these things have been put forth by all are not material to this case at all. Because I take your lordships to on 24th, Bar Council, State Bar Council, election officer, they have filed their counter against whom this relief was called for. They have stated that this president is taking all these false statements. He is not following the rules, regulation, Kotak Bar Association. May I take your lordships to only small point. That is Article 44 of the Kotak Bar Association rules. Your lordship may see. Then I shall take your lordships to all those disputed question of fact, counter filing case, counter case, and all these things I have mentioned in my writ appeal, and they have also filed. Now again they are filing. Your lordship may look to this page 44. May I read it? How the president will file a case? It is the secretary or joint secretary duly authorized by the executive committee by a resolution or initiate any to prosecute any legal proceedings for and on behalf of the association. Then may I take your lordships to Article 31. That is that has been found out by the Article 31. All those allegations which have been taken care of and heard by the general body, blunted false. Because the general body members, they have stated, yes, we will hear the matter and a compromise may be held because of the for betterment of the Bar Association. But this arrogant president, without putting a date and hearing the matter, he has filed this, and by the majority of executive members signed. That is it is not my statement because I am not aware of it. Behind my back, all these things are going on. What has happened? The Bar Council has given that the president is not adding to rules and regulation. Article 31, extraordinary general body, out of which all these things arose. An extraordinary general body meeting shall be convened by the secretary in consultation with the president on the requisition of at least 50 valid members in writing addressed to the secretary stating the purpose of such meeting. For the purpose of identification, the members are to put their signature in full and legibly in the requisition and state their enrollment number. Now, in the writ application from their records, I may bring to your lordships, my lord, not a single person out of 50, only one most probably. And everything is signed by, may I take your lordships to, that is, page, it is annexure 2 of the writ application. Their paper I am taking, that is running page 88. Your lordship may see, running page 88. Nobody has this enrollment number. For out of which they have.
No, the problem. Whether your client is removed from
that is illegally the State Bar Council. May I take now? May I take your lordship?
You will answer.
No.
No, you will answer. Then
you don't want to answer questions. You have to answer.
Suppose I shall tell something. It may not be valid. State Bar Council has given the answer by filing counter that no, she cannot be removed, and they have suppressed material facts so that contempt proceedings should be started against.
Her name has not been deleted from the list of enrollment of the Bar Council. It is there.
Yes, so that election officer followed it. He has also said that.
And we not answer this answer. Then you can explain us.
Sorry, ma'am.
We are asking you whether the name of your client is removed from the bar roll.
No, not at all.
It still continues.
Yes. Still means
kindly see
in the
answer to their IML.
Annexure 2 to the IA. Go to
No, my lord, we are now on that previous case, writ appeal. Then here now again they have put this immediately. I have filed this IA. First, that non-speaking order will go, then matter will be solved. That Bar Council, your lordship is very much put a very good question to me that whether it has been removed or not. That Bar Council counter affidavit it will be.
No. What about the Bar Association?
Association, they have filed the bar, by suppression of facts, they have suppressed that secretary has put a, may I read? Very small paragraph, may I read that? They have suppressed the material facts. The secretary has written a letter to the secretary State Bar Council that this president is doing all these illegal things and they have illegally removed, passed this order. This should not be taken into consideration.
Her name still finds place in the role of the Bar Association or not?
No.
Bar Association.
That has been, we have been putting that.
Yes, for that they have approached this Honorable Court to delete her name. They approached this Honorable Court in the writ application to direct the opposite party number 1 to 3, means Bar Council as well as the election officer to delete her name, not to participate in the election because she filed her nomination on 9/3, 7/3. And election was on 29/3, but they filed after the process
Madam,
was
there are
starting.
two things. One, the list prepared by the Bar Council for the purpose of election.
Yes.
That is one.
Yes.
Whether her name appears?
Yes.
Number.
In the
number
Bar
two.
That annexure,
Name appears.
annexure, that is running page starts from their writ application. That is 109 it starts. 109.
The name appears.
Milord, it was for the
378.
last year election.
Huh?
It was for the last year election.
We are on that.
For this election.
For this year, my lord, may kindly see annexure 2 of their present IA, Milord. 1042. Page
Name appears.
Page 30. No, Milord. But you kindly see page 31 of the present IA number 1042.
Yes, that is.
Serial number 393.
Yes, it is there.
393 is deleted. That is
Deleted
erased,
by
erased.
letter number.
Deleted by
Letter number so and so, dated so and so for Odisha State Bar Council.
Deleted by the order.
letter number OSBC dated 25th of February.
February 26 of Odisha State Bar Council, my lord. State Bar Council has directed to delete her name.
Page 20 of the IA.
OSBC has sent the letter.
Yes, my lord. Odisha State Bar Council.
Letter dated.
Letter dated 25/2/2026. That is before election process started. For the current election.
For deletion of appellant's name.
Yes, my lord.
On what ground?
That, my lord, the State Bar Council, that
May I explain, my lord?
because, please. Please call, my lord, one more thing, my lord. Now the election process has started. Present new election officer has been appointed. President, secretaries are new for the current election. They are not party to this proceeding, my lord.
Why?
No,
Sorry.
we were president had filed the writ petition.
My lord, I was president in 24-25. I filed writ petition asking the State Bar Council to delete her name as her membership has been cancelled.
Membership was cancelled because of disciplinary action of
Yes,
the
my lord.
association.
Yes, my lord. And that discipline, I have not taken that decision, my lord. If my lord look to my date chart, my lord, 54 members made a requisition, serial number 4, kindly my lord see my date chart. Serial 4. Sanjukta Patra and 54 others filed complaint against Ms. Chamelit Raut, present appellant, before Secretary Cuttack Bar Association Annexure 2 to the writ petition. My lord, when I kindly see page 38 of the writ petition, my lord. Page 38 of writ petition. That petition I have annexed, my lord. All the 54 members have signed, my lord. My friend said nobody has signed, only one member, my lord, will get and all members' signature, my lord. Thereafter,
Mr. Agarwal, this election is for 2026-27.
That
No,
was-
this election.
This is for 26-27.
26-27.
Yes,
This is the electoral law. No.
yes.
Name appears?
No.
No.
No. That's why I said, my lord, in the earlier list, his name appeared. Then the State Bar Council communicated to the election officer to delete her name. So accordingly, the election officer has mentioned there, deleted as per State Bar Council letter dated so and so.
The OSBC sent that letter, why?
That, my lord, State Bar Council will say.
Who appears for the State Bar Council? Is it a party?
Yes.
On behalf of Mr. Smita Patnaik, I am appearing.
No, the State Bar Council is a party.
Yes, madam.
You are appearing for that?
Yes, madam.
OSBC?
Yes, madam.
Okay. Why OSBC sent that letter?
Earlier, my lord,
Removing his or her name? Her name from electoral roll.
my lords, earlier it was mentioned, my lords, due to a mistake, my lords. Subsequently, we, after going through the application of the Cuttack Bar Association, we removed it, my lords.
You removed?
Yes, ma'am.
You removed the name?
Yes, ma'am.
On the ground that she is
She was expelled.
membership of the association.
Yes, ma'am.
That whether that or removal order, have you challenged that removal order? Order which removed your name from the membership of the association, not Bar Council, association.
Yes, my lord. That is challenged before pending before the State Bar Council. All those things are there in the writ application.
One second. Whether such removal has to be
And this removal.
No, that is to be challenged before the Bar Council.
Yes.
Which section?
May I take your lordship to my lord there?
Just show that.
First, page 88, your lordship may see. My lord and friend also stated about that. Basing on that letter, extra general body was called for. That is illegal, which has been mentioned by the State Bar Council. Then election officer may take a lordship to that. Most probably now the answer is something different because that single judge order is present. So that and the matter is delayed so much of one year is going to be passed. Now they have removed. That may be the reason. My name was there in the I application. May I take your lordship to page 20? My name was there. Then all on a sudden, I went to file my nomination paper. I saw that my name in my
when the
page 20.
When the disciplinary inquiry was held, and how her name was
Yes,
Yes,
yes, my lord. My lord, on 5/8, on 3/8, my lord, Bar Association members made a requisition. 5/8, my lord, executive body decided to refer the matter to disciplinary committee. On 28/8/24, disciplinary committee, after taking all the factors, decided to cancel the membership, which is available, my lord, at annexure 4, page 43 of the writ petition.
Was it done after notice to her?
Yes, my lord. Yes.
Explanation is
yes. Yes.
Do you have a copy of that?
I have annexed to writ petition, my lord.
Which is that?
Annexure 4, page 43 of the writ petition, my lord. That entire report has been annexed.
Report is produced.
Yes, my lord. Annexure 4.
Page 4 it is mentioned, in view of the above discussion, Sri Anjan Kumar Jena, who has failed to have control over his junior and having failed to restrict from our indulgence.
Bar was locked, my lord. Entire bar association was locked at one day.
My lord, may kindly see, yes, my lord. Because my lord, may kindly see para 8.
And one.
Your lordship will get the answer. This appellant, on that day, Ms. Chameli Raut appeared before the disciplinary committee and her statement was recorded. Para 8.
Actually, fighting took place.
You know, many things happened that
Visual recording is there. 15 men advocate caught hold of her. Bleeding injury is there. What has happened? And all are united against one girl. And one girl, what she could have done?
Why all they united?
Because something that which should not be disclosed.
She is making allegations against all
Yes,
the members. I take it.
She did not succumb to.
She had been removed from other two bar associations also, my lord. From this, she was member of this bar association, she had been removed. She was member of the criminal bar association because of her indisciplined behavior, she was removed. Now again, she was taken as a member in the Katak bar. There also same situation she is creating.
Girl should not be succumb to their satisfaction. That is the reason.
Sorry.
Yes, my lord, that is the reason.
Then my lord, kindly see.
It is gender bias, 100%. One girl and they are united, that visual is record is there. And may I take your lordships to the general body meeting? They are stating that shows the visual recording, they are not showing it. Next annexure, that is 7.
My lord, FIR.
Yes, my lord, this is a
FIR.
FIR file bleeding injury, she could not be treated there, city hospital, she was sent to SCP. So much, and the single girl, and they were all are united.
Against her.
What is going on?
So
Supreme Court has passed
female member.
How they
only, not male member has not lodged the FIR against her. Female members have lodged
This
the FIR
Balason
against
rape
her.
case, we know. 300 female came forward with the rapist. It happens. 104, may I take your lordship's my lord? The Bar Association, Bar Council has also referred that.
We will read the literature and come back. It's not that easy. Anyway, we have heard it now in part.
But my note might be taken.
One thing, my lord, that most probably because that honorable single judge order exists, so that now for the election they have removed that. That is the only reason. Because, and also things may be seen in this way, that if State Bar Council has filed in favor of me and an election officer, they cannot go beyond that, otherwise they should be put behind the bar. This institution should be cleaned. What is going on? I am having 3 proofs. Ladies advocates, they are not able to practice here because of this such type of behaviors. They will come forward.
No.
What is going on?
Not possible to sit across the table and discuss.
Yes, I wanted that. May I take your lordship's my lord? The senior advocates, they said together, they said that we take some 7 days time to take a decision. They did not.
Mr. Agarwal.
My lord.
All senior advocates spoke in favor of the girl, and they wanted to see the visual. They did not show it, and that is with my mobile.
No, if
When I will
with much humility, my lord, that
humility first, my submission before your lordship, the more the power, more restraint should be used. And because we are elite members and bar members, more restraint is expected by the public. And if it is happening within us, it gives a very bad picture to the society.
No.
So that for filing false affidavit, contempt should be drawn against the person that petitioner. Contempt
We
proceedings should be
understand,
started.
madam.
False affidavit, I shall give the proof.
But can it help you right now? We will be going forward.
Question of helping does not arise. 1 year has stopped. The girl has been deprived because of the bias.
No, other will.
Justice should prevail.
How?
And this institution should be cleaned because that single judge bench order should go because I could not take part. I could not be for 1 year. That wrong order was passed in a writ appeal that was corrected in the review. Now before your lordships. And if this were delaying matters.
We have a small request. This is an online court. Many will be seeing you. They may mistake you. Or we may mistake us. Therefore,
No, I request not
conduct
to
the thing very
mistake it.
honorably.
Because it is a
Many people, students will be seeing, academicians will be seeing.
truth should be truth should be seen by all. It is good always, my lord. Because it is an attempt, gender bias.
That's all right.
All my advocates, they will be united and they will take this action against such a small post.
When election,
When the president for filing false affidavit, he should be put behind the bar. The bar council has also stated that.
now you are saying so many things against the bar only, and you say somebody should be put behind the bar.
The president, I am not against bar. The president he has no right to file the case.
Let us.
So that in person he has filed this case.
Challenge his order. Have you challenged your removal?
Argument is this
Making all suspicions.
cost should be heavy cost should be imposed.
Let us.
Milord.
Now,
Being a president,
now it is for you. You take madam for
Honorable single judge. Tried his best
speak of illegal things.
tried his best to compromise it. Honorable single judge, the day on 28th, he kept the matter in chamber, but knowingly she has not appeared before the honorable single judge. So
Again, my lord, wrong statement. 28th, it was not in the list.
the gents are speaking in a very humble voice, but your voice is very effective.
My lord, it happens.
It happens good
What
also.
persons they
But we are asking,
very
Mr. G,
polite way.
so many no amicable settlement in this Behra.
My lord.
Yes, what can be done in this matter? It's an in-house matter. See, passing some order
Yes, we wanted that.
may not be that.
The senior
It
advocates
will appear
wanted
in
that.
all newspaper. That will tarnish the image of a section of the bar at least. Therefore, what should be done in this matter, Mr. Panda? Just what can be done in this matter?
may I suggest something? Agent secretary and president are not the party. Let them be called. Your lord, they have to take a call on this.
How she has grievance against them only. How? What will be? What benefit?
Because that was for the election held for the year 25-26.
Yeah.
Now 26-27 and the president who had filed it petition, he retired on the day of election 29-3-25. He was no more president from 29-3-25. After 29-3, new president, new secretary has joined, new executive body has come. They have not taken any step that, look, my membership is concerned, please. She could have approached them. Please withdraw that my consent.
At least now.
Yes.
If suppose we request you.
Yes.
She is a lady. Sometimes gents also commit some acts. They also may commit, we do not know. Okay. Now why can't you sit under the shadow of a tree and follow? Sister, what you are doing may not be correct. You sit here. We will amicably settle this issue. That should be the approach. Because this is in-house matter.
That
we is passing some order and
if your lordship, that is also general body also gave an opportunity that you can settle within 7 days so that we will not remove. She has not gone to the general body.
Again, wrong statement.
Please,
madam,
please,
madam.
Wrong things.
That single judge also kept the matter in chamber. Milord, thrice matter was adjourned because he was not present.
Now, you all seniors sit together, settle this issue.
Milord, I am ready, but Milord, the thing is, now the present executive body
If
is
you do like that, whatever we want to achieve to get
Yes, I got your lordship, sir.
Even that you will
One
lose.
false thing can something will be done. Obviously, on 26th, I was very much present, humiliated.
Anyway.
I have applied for copy of the order and they are again today filing. I was very much present.
Very well. Now, some senior members
Sit, Mr. Bedra.
My lord, Lordship may form a committee by taking nominations from the parties.
Sit down.
And senior members and 2 lady members.
2 good lady members.
2 good lady members.
About 2-3 seniors. Equal
Can
number of seniors.
Can it not be given a logical end?
To give a logical end, this exercise. Otherwise, logic, how logic operates? Life it is. Life does not go by logic.
Yes, I do accept. And the general body also, they wanted, the senior members wanted compromise. That was, they did not. And today also filing false affidavit, madam.
This is a battle, therefore,
I have filed an application to law contempt against them for suppression of facts and misleading the court for filing false affidavit.
Yes, you are always free to do it.
I have applied for the copy of the virtual A that I was said that no, that is not available.
No,
but the senior counsel, they will say they were present.
Whether your client has to come from which place?
Baba Singh.
Yes. You are here. But why can't you try for amicable settlement? You want to go on fighting the battle like this? How it will help you? You have seen all battles that shedding tears will not help you much here. We are asking you something sensitive. See, all fighting is going on. LTT is finished. Okay, like this, who went on fighting, nature has not helped them. Instead, we understand English. Understand English. Why can't you sit with the committee? We shall form a committee. Choose your member also. And we shall form a committee. Sit with them. Argument will not take you anywhere. By any amount of argument, rails cannot be brought. Nor rails cannot be, they can be halted either. No amicable settlement. Sometimes mistakes happen. Mistakes happen every day. Is it? Therefore, why can't you sit with the committee, explain, then committee will give a verdict that we can incorporate into our judgment itself.
Yes, imposing some heavy cost.
That
That also I mentioned in the time.
Your
nomination file, she spent such a lot of money.
By this, what lot of
My lord may kindly see order passed in this. So that's why I.
Mr. Agarwal, now
you propose for 3 numbers.
Now we are not on war.
See, Vibhuti Mishra, that election officer, he may be there.
Kindly you give names of
Vibhuti
persons.
Mishra.
Give names of 3 persons of your choice.
Vibhuti Bhushan Mishra, who was the election officer.
Not you. Madam, not you. If you threaten like that, nobody will come forward. If you call them affectionate,
No, my lord,
then they will come forward.
Your lordship should understand my predicament. For 1 year, after filing nomination, she has been kept aloof.
What the heavens have fallen down.
Yes, my lord.
It is not a member of parliament. After all, a member of Katak Bar Association.
Very small thing. Since I told that this time you should not contest.
Madam,
She was interested. I said that let us come to a logical end. Then next year you may contest.
We will do something now. We will form a committee. Mr. Agarwal and G. Behura Agarwal.
Your lordship may.
No, they are the members.
Because I am the counsel.
You may not be. You may not be.
Yes, please.
Our Panda, our Behura,
Your name.
and you give me that option.
Yes.
If you say
Last
then you want to generate a war itself. And other 2 members, Mr. Das.
Anyway, I leave it to your lordship. We have no.
Mr. Das, come. Das also will be one of the members.
I have no.
Okay.
But one thing may I say, all compromises are illegal. All compromises are illegal. Anyway,
Section 89 of CPC is structured on that way, not on fighting. Section 89 is the very sacrosanct provision of CPC. Madam, which member you want to nominate?
Member କାହାକୁ ରଖିବା ପାଇଁ ପଚାରୁଛନ୍ତି। compromise ये रहते तो हम तो कहा
Your lordship may.
We'll have it tomorrow. You make sure, give a name, give names.
No, better not. Your lordship may keep the present president and secretary as the member of the committee so they can.
no.
No, but they are not agreeable to that.
Below this. Present,
Mobita Rai.
I am asking for present president and secretary, my lord.
Whether present
He has
objection.
filed the leave.
Present members of the association also.
No, they are not.
No.
Because they are behaving so roughly. She is being locked outside the bathroom. These are the things going on.
No.
Pano khaygi chepo. They are spitting on her bags. I said that I restrained her not to file affairs for small things.
Matter requires further hearing. Call in the last of the please.
Last